Item,
Eh?
item number 30, my lord. The respondent has filed their affidavit, my lord. We pray for some time to file our rejoinder, my lord.
30. Yes, what do you want?
Time to file rejoinder, my
File?
lord. Rejoinder, my lord.
Don't mention these matters like this. No. No adjournments. We'll see when the matter reaches.
Come on, please. Proceed. And here is a stay order, and I will be the stay order.
You have filed some application?
Yes, and
Huh?
filing the application for the couple of sir. As there is a stay. Presently, affidavit has been submitted in this along with this application.
Will come up for admission orders.
For us, my lord, present time,
Orders. Service is not complete.
but Indian code has not.
So it will come up for admission. We'll see. When do you want it?
But on 13th,
Absolutely no. 13th is a Tuesday. 14th.
pleasure, lordship. On 19, maybe come up after 2 weeks because they are waiting for some instruction from the
Huh?
some development is arise.
What
Item number
development?
19,
You are for the petitioner.
petitioner.
See when the matter reaches. Don't mention unless there is a great difficulty. Somebody's house has fallen or some eviction or anything has happened.
Take to mention item number. This
2017 matter. We'll see when the matter is taken up. One adjourn these type of matters.
My lord, last occasion, lordship matter was taken up, that petrol pump matter, my lord. It was fixed today, my lord.
Oh yes.
It is not
We'll
listed.
upgrade it at 2.
It is not listed, my lord.
Oh, it's not listed.
Lordship given the for upgradation also, my lord, to mention it.
What is the name?
AK Das versus Union of India.
Polen Kulta, no. Let's give it to him. Name. If I have I think I directed it 9-8.
Yes, yes. The order is also there.
There is why the matter. And inform the other side. Give a mention memo also.
I beg to mention item number 35, Lord. It's on for today. Must be
Oh.
out of station.
Who?
Item number 35.
Other side has not appeared. So you appear, don't worry. We'll see why the other side has not appeared.
Met, you know,
Yes, what is this so big a matter?
contempt for disobedience of an order passed by your lordship
Hmm.
regarding the entitlement of the text component of the petitioner's PVC bids.
Oh, that judgment.
Minor. So they have issued one after another letter, and at last they say possibly they will prefer appeal against that, something like that, so they are not going to pay. These communications I have annexed, so we kindly have a look after I serve the copy of the judgment. Property part of the order is at page 209.
Page?
Page 209, para 44.
209. 209 is my direction.
Final, property
Oh.
part of the lordship direction.
Yes.
I'm just reading that part. This court is therefore of the opinion that the petitioner herein would be entitled to his PVC claim in terms with the contract of and GST paid by the petitioner from its electronic credit ledger has to be taken into consideration while computing the PVC claims of the petitioner. The petitioner would be well advised therefore to take steps in terms with the JPO dated 29/1/2021 for making its PVC claims, if not already done, and the respondent railways shall pay.
Then what did you do?
Thereafter, I submitted a copy, my lord. Approximately kindly have a look from
Then
page
what happened?
76.
Has this judgment been put to appeal?
They are again raising those issues which were before the adjudication by your lordship. The first is page 276 after they got the certificate copy of the order. In reference to the above subject matter and letters under reference above, agency has submitted the judgment and copy of the Guwahati High Court against writ petition number so and so, along with agency's PVC claim against CA number so and so. Legal opinion was also been received to comply the Honorable High Court order by letter under reference. I'm reading my page 276.
And why you are making so many people a party?
Two of them, they have communicated and then they have, two of them are involved, my lord. These two persons have,
And why you are making the third one?
third one is the page 276 letter issued, first letter issued.
Because the third one, Manoj Kumar Meena,
Right.
is as regards comply with it. Then why you are
Yes,
making him a party?
at this stage, notice may go only to 1 and 2.
Huh?
I'll pay a notice to only 1 and 2 only. But
Notice making it returnable on 13th of September 2024. The instant application has been filed alleging willful and deliberate violation by the respondents to the judgment and order passed by this court dated
6/6/2023, page 180.
26th
Right, 26th of June 2023.
of June 2023, passed in WPC number 683/2021. This court, while perusing the petition, have seen that the respondent number 3 who have been arraigned
Hello, here, may I just interrupt for a moment? Page 286, possibly notice may go to him also. He has ultimately said returned, bills are returned. So he's also, my lord,
understood, but he has himself stated
the
that
first letter is correct. Well, page 286, Dr. Kindly see, it is his letter. Now he says has been returned.
where
Page 286, my lord. It is his letter. Annexure 11 at page 286. He has returned the bills, my lord. Second paragraph. In reference to the above subject matter, it is to inform you that your PVC bill number so and so amounting to rupees so and so submitted on so and so pursuant to the Honorable Guwahati High Court order dated so and so in case number so and so has been returned by the associate finance with observation by so and so. He is only
what is
intimating
the
about
compliance sought for? The compliance sought for PP3. PP3 is
289. ma'am.
to the office letter dated on the subject. Then
This observation is of respondent number 2, page 289. Ma'am. And he is also supporting this, saying that return.
whose letter it is at page 293?
There will be a board man. Communication, not directly to us. As always, they are very vague.
Issue notice making it returnable on so and so. A deliberate violation of so and so. The petitioner is directed to take steps upon the respondents numbers 1, 2, and 3 by way of registered post as well as usual within 3 days. Now, by tomorrow. Gusto. The respondent shall, on or before the next date, bring on record their stand as to whether there is any violation to the order, to the judgment and order dated 26/6/2023, passed in so and so. We fixed it. 13 September, isn't it? And number 2,
Please, Your Lordship.
Mr. Mazumdar, I am the only judge who fixes dates. Yes.
Please, Your Lordship.
Yes, what is this?
So this is the contempt petition for non-violation for non-complying the or direction given in the order dated 15/5/2024, Your Lordship. The operative part is at page 16 and 17. Your Lordship.
Then what happened?
So we have filed the representation along with the certified copy and all the annexure of the petition, Your Lordship, before the Deputy Commissioner Borpeta, Your Lordship, but thereafter nothing
31st May 2024. Today is what?
happened thereafter, Your Lordship. No steps have been taken by the respondent authority.
Hmm?
Till date, nothing has been happened, Your Lordship.
For the purpose of facilitating the respondent number 3 to the other petitioner shall submit the certified copy of this order, a copy of the petition along with enclosures at his office within a period of 10 days from today. It is not on 10 days from today.
There was a delay of 5 days because of the,
Then why should this court at all entertain? Because from 10 days, another 45 days. Isn't it? And the word used is preferably. Why you are so urgent? You delayed by giving after 5 days.
Lordship, by taking the advantage of that and next of kin certificate, Your Lordship, the private responding that petition has taken so many benefits, Your Lordship.
Understood.
The petition.
I think you should wait for some time. Why you are moving so early? There was a direction for you to give within 10 days. So you should have given by 25th. You have not given. You gave it on 31st. Thereafter, the word you use is preferably within 45 days. So you give it sometime on 31st, which means in the month of June. From June, July, we are just in August. Then wait for some time. When the word preferably has been used, the court did not say within 45 days. Contempt jurisdiction should not be initiated so soon. If we initiate the contempt jurisdiction so soon, it would not be proper. Who is the person who is to decide?
The Deputy Commissioner Borpeta, Your Lordship.
Huh?
Deputy Commissioner Borpeta, Your Lordship.
Madam, get your information. take it up on, for motion on one day is the 9th. On 16th, this will come up for motion. Give a copy to her. Just ask the deputy commissioner whether he has complied with that order or not. Huh? Give a copy. Ms. M. Borman is requested that the learned junior advocate is requested to obtain instructions as to whether the order dated 15/5/2024 in WPC number 2362/2024 have been duly complied with by the respondent herein. And if not, how long it would take to dispose of the representation. This is the matter on 16th.
Can it be 17th, my lord? Can it be 17th? On 16th, I have
17th is Saturday, madam.
some next Monday. my lord, because
Okay,
my
we'll have
sister
it on
is still-
19th for motion.
Note three.
Yes, Mr. H. Sharma, kindly obtain instructions in this matter. Whoever it is, obtain instructions in this matter. Ms. M. Borman, the learned junior government advocate, is requested to obtain instructions as to whether the directions so passed by this court on 8/1/2024 in WPC number 473/2021 have been duly complied with by the District Commissioner, Kamrup Metro. Pusto.
Petitioner is not available. It's a contempt case, no file which has lordship.
Not necessary.
What
You
what
just-
instruction
I'm only asking you to obtain instruction.
regarding lordship?
Because there was a specific direction that money has already come, but within 30 days to make the payment. Just that. I'm not issuing notice
Regarding
or
the reference lordship, at least a copy of the writ petition is, sorry, contempt petition.
এটা কপি এটা দি দিব contempt petition নয় এখনো I've asked her
Lordship.
when I asked you, you said ask her.
Lordship.
When I asked her,
I'm
then
sorry,
why
Lordship.
are
I-
you
I'm
stepping
sorry.
into her shoes?
I'm sorry, Lordship.
She knows how to say. I think
Sorry.
she's not
I'm sorry, Lord.
obtain instructions as to whether this is the matter again on 16/8/2024. At a photocopy at a DD board.
Let it be 19, my lord. 16, I have some personal difficulty, my lord. 16, I have personal difficulty. I may not be available.
Oh, no,
Let it be
19. You just get your instruction as to whether it has been complied with, because there was a specific direction, the money has come, but, and as such, I disposed it of, saying that as the money has come and the council who was appearing for the district commissioner categorically said, we are going to do it in any day. So I gave another 30 days. That's all. They come up out here saying that they have not fulfilled. But there is a problem out there where they have issued some notice. Where they have sent it by registered post. So you may not have got it. So that is why I'm again asking you also. Because the order, if it is passed by this court, needs to be complied with it. Because there was a specific statement being made when the matter was taken up that the money has come, we are going to disperse within 7, 8 days. And
By the
then
time
also I gave
we
30
disperse
days.
or-
Tell that. The photocopy to দিব। আর একটা প্রিন্ট আউট এটা উলাই দি দিব না? Yes, what is this?
At page 9, your lordship. Direction is at page 11, your lordship.
Yes, what is your, why have you filed the contempt?
Filing this.
Huh?
Filing this order, your lordship,
What?
the
Order says what? Page 11.
directed
In
to
view of the
verify
above,
claim.
this court is of the considered view for that for the ends of justice, the writ petition can be disposed of with a direction to the respondent authority, more particularly the respondent number 3, to verify the claim of the petitioner and proceed in accordance with law within a period of 1 month from the date of receipt of the certified copy. Meaning thereby was what? Proceed in accordance with law will become serally. Verification is to be done within 1 month.
They have not verified, my lord.
How do you, where you? Yes, they made a statement that they have not verified. Let us see. Hey. Too vague a statement.
Para number 7, your lordship.
Too vague. Very vague. A contempt cannot be on vague statements. You say that you have approached many times. The direction is to verify.
But they have to verify.
You say that they have not verified. Where have you stated that they have not verified? Because the payment as per this is the PHE.
PSC department.
The PHE, the payment would be only as per the ERO. This one, Tamser Then, because the word uses in accordance with law. Tamser Then,
In the order, my lord.
file proper affidavit. Mr. So the learned counsel appearing on behalf of the petitioner, seeks some time for filing an additional affidavit, bringing details, bringing on record as to whether there has been, as to whether the verification has been, whether bringing additional affidavit to bring on record certain additional pleadings. List the matter when
Next week.
Ne-
Next week, your lord.
next 16.
Exactly. Page 62 to
Mr. B. Islam, what is the direction?
Not your-
I have asked them to submit a report within 1 month of that order. Order was passed on 21/7/2024. We are yet to reach 21/8. Then the petition being premature, the instant contempt petition stands dismissed.
My lord,
Absolutely with cost,
order date is
50,000 on you, huh?
passed in the year 2023, my lord, not in the 24, my lord. Order dated 21/7/2023, my lord. Passed in WBC number 1997/2000. Worship Court make a direction. The petitioner is entitled, and the amount be released within a 60 months. Worship Court passed the order on 21/7/2023, my lord. The 11 portion is page 6,
Where is the order being served upon the authorities?
but on 28/11/2023, madam. That was, order,
Why should we initiate at all a contempt?
but that amount was not released.
Why will it be released? Order was passed on 21/7. You give this thing on submission of the High Court's order on 28/11.
20,
Then
madam,
28,
not 23, madam.
page 66.
Madam. That in the stem, madam, it is shown, madam. There is
Come on top of it. 28/11.
28/11/2023, madam.
Then you give it on after 6 months, after 4 months, 4 months. Why?
Initial was, that was not enclosed. After passing the order, my lord, on, my lord, 21/7/2023, my lord, and immediately that order was submitted, and the last,
Where is it submitted?
that was not enclosed.
Then you must have written something. Where? And did you submit a copy to the circle officer?
So given, my lord.
Huh?
Copy to circle officer is written.
Did you submit it to the circle officer?
Right.
Where is it?
That was a copy to circle officer.
Circle officer received it on 30/11/2023.
Right.
Then why did you submit so late? Heard Mr. B. Islam, the learned counsel appearing on behalf of the petitioner. This is a repetition, the issue notice making it returnable on 13th of September 2024. Petitioner is directed to take steps by way of registered as well as usual upon the respondents by tomorrow. Date to deliver. The petitioner is aggrieved by on account of the non-compliance to the order dated 21/7/2023 passed in WPC number 1997/2022, whereby this court taking into account the submissions so made on behalf of the respondents in the said petition, directed the Circle Officer Bilasipara Revenue Circle to submit the report within 1 month from the date of the said order, and if not, and the district level committee. Mr. Islam, what do you want by this contempt?
uh, the amount whatever
Who will release the amount?
Deputy Commissioner. Ma'am.
When? When? The release would be only after the district level committee have received the report from the circle officer and gives a recommendation. District level committee is not a party. How will the district level committee, how will the deputy commissioner pay unless there is a recommendation by the district level committee? And you have not approached the district level committee also?
And they fix the matter up.
And file it like this.
Filed by my junior.
Have you mentioned anything as to whether the report have been submitted? Then nothing.
Matter may fix after 1 week. ma'am.
What? No. This is a case for dismissal outright. Come after some time, move properly. You can't do it like this. There's not a single whisper that a report have not been submitted. Then only I can catch hold of the circle officer. There is not a single whisper that a report having been submitted, the district level committee have already decided, by the deputy commissioner have not released. Not a single statement. You can't come up in this type of matter. Like, oh. The instant heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. This is an application filed seeking initiation of contempt proceedings against the respondents in view of the alleged violation to the order dated 21/7/2023, passed in WPC number 1997/2022. For appreciation of the instant application, this court finds it relevant to take note of the directions which was passed by this court. The directions which have been passed was passed at paragraph number 7, 8, and 9. Is reproduced herein under. From a perusal of the contempt petition, there is not a single allegation to the effect that a report have not been submitted by the circle officer. There is not a single allegation that upon the report being submitted by the circle officer, the district level committee have not made the recommendation. There is apart from that, the district level committee, neither the chairman of the district level committee has been made a party to the instant proceedings. Apart from that, there is not a single allegation also that post the district level committee's recommendation that this deputy commissioner, district commissioner, who have been arraigned in the instant proceedings have not released the funds. Taking into account that the allegations, taking into account that the statements made in the instant application do not, prima facie, do not make out a case of initiation of contempt, the instant application stands dismissed. However, without prejudice to the petitioners to approach this court, however, without prejudice, the petitioners are given the liberty to again approach this court after taking appropriate steps and also by filing a proper application furnishing better particulars.
Takes.
Six, 7, 8. Yes, what it is.
My lord, this petition has been filed, my lord, for not allowing the petitioner, my lord, mutation, my lord. In this regard, it
That
will-
one-
Order passed.
Yes, my lord, it is said that it is rejected.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. M. Bormon, the learned junior government advocate appears on behalf of the respondents. The instant petition has been filed on a limited aspect. Inasmuch as the petitioner is aggrieved by the inaction on the part of the circle officer, Azara Revenue Circle, in disposing of the mutation application so filed by the petitioner. This court, by an order dated 29/7/2024, had directed Ms. M. Borman, the learned junior government advocate, to obtain instruction as to why the order had not been passed. It has been duly informed. Today, it has been informed by Ms. M. Borman on the basis of a instruction issued by the circle officer, Azara Revenue Circle, that the petitioner's application so filed for mutation was rejected. The said instruction is kept on record and marked with the letter X. This court disposes of the instant petition, thereby directing the office of the circle officer, Azara Revenue Circle, to provide the petitioner a certified copy of the order whereby his mutation application has been rejected within 7 days from the date of application of the said order.
Public. And the press memo parties.
Tell me now.
Notice, Lordship.
Why? You notice making it returnable on 23rd of September 2024. The petitioner is directed to take steps upon the respondent numbers 1 and 2 by registered post as well as usual within 3 days. The case of the petitioner herein is that the petitioner's application the petitioner's claim was rejected by the respondent insurance company. Without any justifiable cause. The respondents are directed to respondents are directed to bring on record their stand by way of an affidavit on or before the next stage. The maintainability of the writ petition is, however, kept open.
Wait, please, your lordship. Lordship, sincere apologies. We are supposed to file the affidavit 2 days back, but the petitioner is unable to come and sign the affidavit, lordship. Lordship, may please to allow us some time, lordship.
Understood. Why you are not applying online then?
Lordship, we have applied it online through a friend of the petitioner, lordship.
Go and apply online. Better you go and apply online. Whatever you want, apply online. They are asking to you to apply online, apply online. Instead of this, keeping this matter pending out here makes no sense. It is not going to help you.
Lordship, may please to at least the parties, lordship.
No.
Lordship,
Nothing doing.
the fraud has already been done. The annexure 1, lordship, they have already muted their names, lordship.
Mister, I understand what is your case. On the last occasion, the matter came up before me.
Yes.
Your basic case out here is that look here, I am the owner of the land. One fine morning, I say that the name of two persons who are the private respondents their names have been mutated in the record of rights. Under such circumstances, I ask on what documents this was being done. And then you come to learn that it is based upon some fraudulent documents. So you ask for certified copy of those documents which have not been given, and as such you have approached this court. Isn't that your case? I asked you on the last occasion that these officials were saying they kindly apply online. But you said, then I asked you, did you apply online? Could not answer. So therefore I passed an order to the effect that to bring on record anything by which you have applied online. Isn't it?
Yes.
Now, could this matter be of any relevance if I pass you up appropriate direction? You want at the end of the day certified copies of whatever may be so that you can challenge it in accordance with law. Isn't that your idea? Or are you going to show it somewhere in the public? No, you are going to do that. So get your order out there. If I issue notice, it is only going to delay your case. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Ms. M. Borman, the learned counsel appearing on behalf of the respondents. The instant petition is taking up for disposal at the motion stage, taking into account the limited prayer. The case of the petitioner herein is that the petitioner is the owner of a plot of land. However, to the surprise of the petitioner, the names of the private respondents have been included in the record of rights. Private respondents have been included in the record of right. And as such, the petitioner made inquiries and could come to learn that on the basis of certain fraudulent documents, the name of the respondent number 6 was inserted in the record of rights. It is the case of the petitioner that the petitioner have applied for a certified copy of those fraudulent documents. However, the respondent authorities have not provided those certified copies. Under such circumstances, the petitioner has therefore approached this court. On the last occasion, this court, by an order dated 2/8/2024, directed the petitioner to file an additional affidavit bringing on record documents to show that there was an application filed for certified copies of the deeds in question. Full stop. However, the additional affidavit has not been filed. Ms. M. Burman, the learned junior government advocate, submits that if the petitioner has applied electronically through the online mode in the portal, the respondent authority would definitely provide those certified copies if those are available with the respondents. Full stop. Taking into account the stand taken by the respondent, taking into account the submission made by Ms. M. Burman, the petitioner herein is given liberty to file application seeking certified copies in online mode, and in the event of such application is being filed, the respondent authorities, more particularly the respondent numbers, who is going to provide? Sub-register.
3 and 4, Lord.
But Superintendent of Police, why will he provide? The respondent number 3 and 5 shall provide the certified copies of those documents, provided the same are available with the said respondents. The said be done within a period of 30 days from the date of such application filed. Your purpose is more served.
Much obliged.
If I issue notice in this matter, it will go for another 6 months.
Right, Prisoner.
Hmm.
To cancellation of GST registration, my lord.
Huh?
It relates to cancellation of GST registration, my lord.
Cancellation of?
GST registration, my lord.
Fantastic. Tell me
This matter is covered by lordship order at page 42, my lord.
why.
Because my lord, reason of cancellation was given, but we will find it page 28, my lord.
Ah.
Reason was given, registration is cancelled.
Ah.
And your lordship, none of the cases held that this cannot be a reason for cancellation, my lord.
Where is it?
Page 42 is the lordship order, my lord. As
So
per-
cause is where?
27 is the so cause, my lord.
I mean, the so cause. Failure to furnish returns for continuous 6 months. Hereby directed to furnish a reply to NAIA within 30 days. Okay. Now, what is your reply? Reply?
Correct. Reply was not filed, my lord.
Then why didn't you submit your reply?
Now, my lord, time is over. I have updated my returns and I tried to make an application for revocation, my lord, but system is not allowed because time is over. And
We'll just issue notice making it on 11/9. I fix some other matters. You see, the problem yesterday, I was thinking about this type of matter. Because of you, there's a huge problem which is being faced by the other person also.
yes,
These are all because of this input credit. Why do you need the revocation? You can freshly apply. The only reason why you need is because to avail the input credit.
yes, but I have not done any business, so I cannot ever input.
Huh?
During the cancellation period, my lord, I have not done any business, my lord.
That I can't believe that.
If, my lord.
You can't believe, no, nothing doing. Why you are not applying for a fresh one?
Thank you, yes, one, my lord. I have to update all my returns. I have to update all my returns. After updating all my returns, I have to file a final return. Thereafter only I can apply, my lord. And then they will give a fresh registration. These activities I have done already here, my lord. I have done update all my returns.
Then apply for a fresh one.
With lordship, I can undertake giving. I
No,
will not
nothing
take any
doing.
input, my lord.
Apply for a fresh one.
I will not.
There's
take-
no, there is a reason why. Because of you. Anybody else who is in touch, because this GST is like a value added. So anybody who otherwise would have got an input tax credit, he is also being deprived because of you not filing under 16(2).
My lord, that,
The very serious aspect.
my lord, I can satisfy lordship on 11. I will try, my lord. I will. try.
No.
I will try it on 11. Lordship, I fixed it on 11 since the lordship is fixing.
Yes, issue notice making it returnable on 11/9/2024. Mr. S.C. Kyle appears on behalf of the respondent numbers 1, 2, and 3. Extra copies of the writ petition be served upon them on Mr. Kyle during the course of the day. The case of the petitioner in the instant proceeding is as regards the cancellation of his registration. It is seen that the petitioner was duly issued a notice for duly issued a show cause notice as to why his registration should not be cancelled on account of failure to furnish returns for a continuous period of 6 months. The petitioner did not reply. Why are you saying not reply? There is a mention that your reply.
System generated my lord. I have not submitted in reply. This is system generated order, my lord. It says I have submitted reply, but I have not, my lord. Specific date is mentioned.
Oh, then if he has made a reply, let us assume. He says he has not, but if he has made a reply, then you have to record reasons.
It's recorded and it was considered. Lord.
Where?
Ultimately,
Where is the reasons?
Page 28.
Where is the reasons?
Where is the question is examine your replies
Then
and submission made at the time of hearing.
hearing.
And it is opinion that your registration is liable to be cancelled for the following reason.
What? What reason?
That is.
We set aside this. Nothing doing. Where's my order?
Page 42 is start from page 42, my lord.
এইটো এইখন চাই মেলি এইখন কৰি দিব এইটো পেজ 42 order to give the details to you and do this. He had not submitted the report and there is no return said to be submitted.
No.
Then I would have very well taken it. But when you say that there is a return, I've heard it, and then you have to give reasons, some reason.
That is.
There's no reasons. Disposed.
In.
Mr. Mishra, ask your junior to give the details of whatever that number is, no? The service tax number or whatever number. Just ask him to give it. It will aid in passing. Yes, what is this?
Ship
Oh, your case. Then,
Lordship has asked me to find the LA case. I just received it today morning, Your Lordship.
Eh?
Just received the notice of the LA case today morning, Your Lordship.
then. Friends, I have the honor to say that dark number of owner has not been acquired for the construction. Have been acquired by initiating him. What is your dark number?
864 and 867, Your Lordship. Second is patta number 36.
Okay, well, what are your names? Samsul Haq Loskor.
Yes, Your Lord.
Who is Babul Islam Los Borbhuya?
They are the trespassers, sir.
Piazul Iman, who are under possession of the land. No land covenant has yet been paid. Okay, then you do one thing.
Your Lordship.
Moreover, additionally, 8 years of length on so and so are proposed to be acquired. 867. Compensation has not been paid.
No, my lord.
So don't pay the compensation. Let them move. This is under the National Highways Act.
Yes.
Let them move an application within 30 days. If they don't move, then pay. Huh? I think this is the best way.
One thing I would like to point out, my lord, in my communication, LA case is referred as 35/2020-24. But her notice, my lord, I find the LA case number different. Probably it's some other case number also.
Now this must be for the new one. No, if you see down below, na.
Yes, my lord, that number is not.
No, this is therefore, you see, Jirat pertaining to DAG number 867,
Yes,
Patta
sir.
number 36. Against the Bharat Mala project as claimed by the second party, and you are hereby asked to appear before the undersigned on demand with all the. No, in view of this, you can very well go there.
Lordship, my client has already appeared.
Well, this is in the month of August. When did you get it? 2nd of August.
Received the copy on 6th of August, your lordship.
Understood. When are you to appear?
On 8th of August, that was yesterday, your lordship.
Then you appeared.
They have already appeared.
Then nothing remains.
They have heard his submission and they have kept it.
So, if anything is there, you go there.
Yes, your lordship,
Nothing remains.
your lordship.
No, let them decide whatever. may be. You came out here that those other people will be paid,
Yes, your lordship.
but they have duly given you some notice
Yes, your lordship.
and you have appeared. Heard Miss Escort, the learned counsel, appearing on behalf of the petitioners. Karki Talukdar, the learned standing counsel, NHIDC, appears on behalf of the respondent.
My lord.
Respondent number 2, and Ms. M. Burman, the learned junior government advocate, appears on behalf of the respondent state. The petitioner herein is filed the instant writ petition being aggrieved by the action on the part of being aggrieved by the action on the part of the respondent authorities in releasing certain compensation. In releasing compensation in respect to the land belonging to the petitioner to the private respondents. In the writ petition, it has been alleged that the petitioner that the private respondents are not entitled to the amount as they are only trespassers. And the petitioner is the landowner of the land in question, as well as is the only person who is the person interested in terms with section 2X of the and the only person interested. On the last occasion, this court, the matter came up before this court on 5/8/2024. And in view of the fact that the counsel appearing on behalf of the petitioner was not aware in respect to which LA case the said the compensation was to be paid. Today, when the matter is being taken up, Ms. Escort, the learned counsel, submitted that on 2nd of August 2024, the Circle Officer Sonai Revenue Circle had issued a notice to the petitioner pursuant to the objection filed by the petitioner as regards compensation of the land of Zirat pertaining to dark number 867 under 2nd RS Patta number 36. And the petitioner was asked to appear before the Circle Officer Sonai Revenue Circle on 8th of August 2024 at 11 a.m. with all evidence papers registered sale deeds in support of the petitioner's claim. In accordance therewith, the petitioner had duly appeared before the Circle Officer Sonai Revenue Circle, and it has been submitted that the said officer have duly heard the the petitioner, and have reserved his orders. Under such circumstances, this court is of the, no, full stop. In addition to that, this court also finds it relevant to take note of the instructions so received from the Additional District Commissioner Kachar dated 7/8/2024 in respect to the instant proceedings. It had been stated in the said instruction that tag number 864 under second RS Patta number 36 have not been acquired for the construction of the Silchar dash Irenket IRENE road under Bharatmala project for construction of the road by the NHIDCL. However, 8 kathas, 14 chataks, 11 gonda of land covered by dark number 867 under second RS Patta number 36 had been acquired by initiating LA case number 35/2023-24 in village Saptagram, and compensation on the structures on the land have been paid to number 1, Babul Islam Borbhuia, number 2, Riazul Haq Loskor, number 3, Irfan Ali Loskor, who were in possession of the land. However, the land compensation had not yet been paid. Taking into account the above, this court is of the opinion that keeping the matter pending in the instant proceeding would not be in the interest of justice. Whether passing appropriate directions at this stage would not only be in the interest of the petitioner, but also in accordance with the provisions of the National Highway Act 1956. This is done under National Highway Act. Na? Under such circumstances, this court disposes of the instant writ petition, thereby directing the respondent, the competent authority, directing the respondent number,
Patent authority has not been,
no, directing the circle officer, Sonai Revenue Circle, to pass the to pass the orders, to pass appropriate orders on the basis of the hearings so conducted on 8/8/2024. This court further observes that in the eventuality, the state official passes an order against the petitioner would be at liberty to approach the competent court in terms with section 3H(4) of the National Highways Act 1956. Under such circumstances, this court further directs that the respondent authorities, after passing of the order by the circle officer, should not disperse the compensation for a period of 30 days, thereby enabling the petitioner compensation for the land for a period of 30 days. In respect to the compensation for the land, However, in the circumstance that the petitioner fails to produce any document showing that the due application has been filed under section 384 of the National Highways Act 1956, the respondent authorities would be at liberty to release the compensation in accordance with law. Yes,
Create notification issued lordship, wherein Dag and Patta number of the petitioner land was not incorporated. Lordship, otherwise, site proposed map lordship, by which the process of land acquisition initiated lordship, it affected the land of the petitioner.
no, what is your prayer?
Lordship, there to pose it, inquiry lordship, whether my land was included in the proposed land acquisition proceeding lordship. According to me, it is affected by the proceeding,
So
but it
whe-
was not incorporated in the.
no,
CA
whether it is there or not will be there in the notifications.
It's not there. That's why we
So
have
if it
made
is not there, it cannot be.
lordship, but other map shows that it is affected.
Huh?
It's affected.
How?
Map,
What map? Where's the map?
lordship, that is it,
Whether your Dag number is there?
lordship, my tag number is there.
Where?
Lordship, kindly have a look at the page 19, annexure 3.
Huh?
Page 19, annexure 3.
No. I'm asking you, where is what is your Dag number?
Lordship, my tag number 554, patta number 243.
554.
Lordship,
Village,
village lordship, Dekasang.
Dekasang.
Lordship, I have also filed a representation that was not considered.
Dekasang. Dekasang, your number is
Lordship, kindly have a look at the serial number 23.
of
Here,
page
page lordship
16.
16,
Dekasang 554, PP number 80.
lordship.
This is your land.
It is my brother's land.
Then?
That is included in the list. And my portion was not included in this list, lordship. That is why I am agree,
So your land is not here.
not here. That's
But
why.
your land number is what?
Tag number, lordship, 554, patta number 243.
So that is not there.
Lordship, that's why. Otherwise, it is affected. That will, road will pass over the land of the petitioner. That's why I have submitted a lordship representation.
Where is the
in
representation?
Lordship, that is at page 23, annexure 5.
An application for inclusion.
Lordship.
Is this a representation? Huh?
Page 23, Lordship, page 23.
Mr. Counsel, this annexure 5 contains lot of other things. What is there in the type copy?
Type copy, Lordship, there is something, Lordship,
We dismiss it.
wrong, Lordship, something.
We dismiss it because you have somebody has certified to be true copy of it, the type copy.
Lordship, it is relevant for.
Where is that person who has certified it to be true? We
Lordship,
asked
it is
that
also
if it is
stated-
a lawyer, we asked the bar counsel to take action. Where is he?
Lordship, it is
Who has
relevant.
done it? Hey, wakalat naman sa. Kar said. Who has done this?
Lordship, it is relevant person.
No relevant portion, nothing business.
In the,
What is this relevant portion? There is nothing. How can there be a relevant portion? Then you are enclosing a document. Document says many things, including there are many other, the contents of the document is not here.
that is not there, Lordship.
Then-
Lordship,
We take
Uh,
action against that person.
Lord-
Where is that? Who is that person who signed it? L.R. Muzumdar and Muhammad A. Islam. I think it is Muhammad A. Islam. No, some Luftika Rahman. Oh, you're okay. We ask you to be sent to the bar council. Fantastic. This is cannot be done. And when that too, when you have certified it to be true copy.
Lordship, it is only relevant person.
No.
Then, Lordship.
Where have you said?
Otherwise, the Lordship, we may be allowed to rectify it. Lordship.
No, nothing doing. This is absolutely, it is a different thing that I know Assamese, that is why. Isn't it, Mr. Sesutia? Do you see this? The entire contents of the document is not there. He has only put subject and the name of the applicant. My goodness.
We may be allowed to.
3A notification, 3D notification in respect of that my lord, that he has annexed, my lord, that has already been published. He has not stated anything about 3A, 3D notification, my lord.
He dismissed with
Rather on the
cost
land of the petitioner
upon you. 1 lakh. And suspend your bar license till you pay that. The very serious thing you have done. You cannot come up like this. This is a case of fraud being committed upon the court. Absolute fraud.
Original photocopy is there, Lordship, in page number 23.
What?
Photocopy of the original is there in page number.
Photocopy of the original is there. Are you supposed not to have the entire one?
Is to what, that
No,
is-
I would have understood. You put the only, you don't put the earlier portion, but only put the relevant portion. I would have understood. The contents has to be there. What you have written, is it there? Then, isn't this a case of defrauding this court?
We have only stated tag and patta number, Lordship.
What tag and patta number? What is the contents of the representation? Have you put the type copy?
That is not.
Then-
Lordship, we will be allowed to rectify, Lordship.
No rectification. This is a case for dismissal with cost upon you. 1 lakh. And also bar council proceedings be initiated against you. As to why you have said to be certified to be true copy. You can't say to be certified to be true copy. You have the original with you? You have the original of this document with you?
Uh,
You have the original of this document with you? Is this the original
photocopy, Lordship.
photocopy? Does this document show that this document has been received by the authority? Where?
That is at page 23, Lordship. Kindly have a look at the left-hand side.
Mr.
Fulani Revenue Circle, Lordship.
Listen, I have practiced in the revenue courts, I practiced in the civil courts, I know. Don't try to make a fool of me. Whose signature it is?
Lordship,
Whose? Whose signature it is?
Lordship, it is signed by Jayanto Lakra, petitioner before your Lordship.
It is
And
signed by whom? A petition writer. It's a serious case of fraud being committed by you to this court. Case of fraud. And you have not enclosed it for good reason why you have not mentioned it.
Otherwise, Lordship, we will do it and file it afresh. Lordship.
Not by you. You have put with a black spot. Black book.
It is bona fide mistake.
There cannot be a bona fide mistake. There cannot be a case of bona fide mistake when you have what is normally done. Put the relevant portion. You may put the relevant portion of what petition you have filed. And what is the relevant portion you have put? The name of the respondent. What is the subject and the name of the applicant. The contents of these not there. When I ask you who has received this document, you say that this document is being received by that person, by the authorities. And this document is signed by whom? Petition writer. Thirdly, this is the document of the year 2021. We are in 2024. What were you doing all this while?
Personally approached the authority, but nothing was done. That's why he devoted this on argument.
He personally approached. Then, if he had personally approached this is the document. Why did he submit this document in 2021? Where are the other representations? Then, have you mentioned, explained it? Explained it? Nothing? Then, after 2001, we are in 2024. There is a process mandated under the National Highways Act. Have you approached anybody? No. Why are you approaching the NHAI DCL? NHAI DCL has no business. They have already appointed the Kala. Then you dismiss it with cost upon you, not that person. Because that person will, obviously, he has been taken for a ride by you. Heard Mr. L.R. Mujumdar, the learned counsel, appearing on behalf of the petitioner. And that is why on the last occasion, he did not serve a copy to Karbi Anglong also. With good reasons, because they will point it out.
But if that is also
Another bona fide. There can be one bona fide, there can be two bona fide, there cannot be so many. Then the bona fide takes the flavor of a mala fide. Heard Mr. L.R. Mujumdar, the learned counsel, appearing on behalf of the petitioner. Ms. Arbora appears on behalf of the respondent number 1. One, and you appear for 2. Mr. Jesuti appears on behalf of the respondent number 3 and 4. The petitioner herein has approached this court seeking a direction upon the respondents to cause an inquiry and to include his land in the list of affected people, and also to pay compensation as per law. It is seen from a perusal of the writ petition that the petitioner claims that he is the owner of a plot of land bearing DAG number 554/748 and included in Patta number 243. The assertion of 243 of village Dekasang under Muzar Duar Dikharu within Revenue Circle Phuloni in the district of Karbi Anglong, Assam. The assertion made by the petitioner about the ownership over the said plot of land is merely on the basis of a kacha patta, and there is no other document showing that the petitioner's right over any other plot of land. And there is no other document showing the petitioners right over the said plot of land. The respondent authorities, for the purpose of widening oblique improvement of to 4-lane with paved soldiers, have initiated an acquisition proceedings under the National Highways Act 1956. And in that regard, a notification has been issued under section 3 capital A of the National Highways Act 1956, for short, the Act of 1956. From a perusal of the said notification under section 3A, which have been enclosed to Annexure 2, it is seen that the petitioner's land have not been included within the purview of the said acquisition proceedings. It is the case of the petitioner that the petitioner's brother's land, which is covered by DAG number 554 and included in PP number 80, have been included in the said notification under section 3A of the Act of 1956. The petitioner thereupon, the said notification was issued on 17/7/2020, and the said notification was issued sometime in the month of July 2021. In the month of August 2021, a letter was written, a communication was written by the petitioner addressed to the respondent number 2 through the ARO/ASO, Puloni Revenue Circle of Sir. Revenue Circle. It is, however, not known as to whether the said document was at all received by the said respondents, as there is not any acknowledgement shown in the said document. Next. Before further proceeding, this court, however, finds it very pertinent to take note of that the petitioner, while enclosing Annexure 5, which is a vernacular document, which is a document written in Assamese, have given a translated copy at page 22 of the writ petition. It, however, surprises this court that the petitioner, while placing the typed copy, did not mention anything, did not incorporate in the translated version the contents of the said application. And this aspect of the matter has been certified to be true by the learned counsel, Mr. L.R. Mozumdar. This conduct on the part of the petitioner as well as his counsel is deprecated by this court, as well as the counsel is also reprimanded. Be it as it may, after 3 years, the petitioner has approached this court. No reasons explained in the petition as to why the petitioner has approached this court after 3 years. Under such circumstances, it is the opinion of this court that the writ petition also suffers from delay and laches and for which the same cannot be entertained. For which this court would not like to exercise its discretion to entertain, more so in view of the conduct of the petitioner. In addition to that, the petitioner have also failed to show any document which should show that the petitioner has rights over the land in question, and also to the fact that the respondent authority have encroached the petitioner's land. This court also finds it very pertinent to take note of the submission of Mr. J. Sutia, the learned counsel, appearing on behalf of the respondent number 3 and 4, who further submitted that not only a notification under section 3A, but the notification under section 3C and 3D have also been issued in respect to the said acquisition proceedings. And such notifications were issued when
That date is not there, my lord. Section 3A, 3D, my instruction is that section 3A and 3D in respect of the document annexed by the petitioner has already been issued, my lord, by the Ministry of Road Transport and Highway and published in the Gazette of India. And my lord, another point, my lord, the petitioner claims his land not in the Dekasang 1, Dekasang non-K. It is in the Assamese version. The contents which he has not annexed, my lord. The land is there, my lord, 5th line, Dekasang non-K. And the notification in respect of Dekasang 1, my lord. It is the Dekasang non-K. 5th line, my lord. The Bortoman Fuloni Rajasokor Odinot, Tuarblak Muja Ontogoto, Dekasang non-K Miadipotta Suenso. And it is Dekasang 1, my lord, this notification.
in addition to that, the learned counsel appearing on behalf of the respondent number 3 and 4 submits that the land wherein the acquisition had been carried out, as stated in the notification under section 3A, is in respect to the village Dekasang
Dekasang 1.
1, whereas the land which the petitioner claims is in Dekasang, is in village Dekasang 1K,
Non-K, my lord.
non-K,
Non-
NK, non-K, which is completely different. And is it your instruction that his land has been acquired?
My lord, his brother's land,
I'm not-
that land has been acquired, my lord, it is 3D notification, the name of the brother has been published.
That is okay, his land.
My lord, that is not there, my lord.
It is also the submission that the land of the petitioner have not been acquired. Under such circumstances, this court is further of the opinion that when the responding authorities did not find it suitable for acquisition of the land of the petitioner, taking into account the project, the purpose for which the acquisition proceedings have been initiated, this court cannot issue a writ directing the respondents to include the land of the petitioner. Under such circumstances, this court finds no merit in the instant petition for which the same stands dismissed. However, in the facts of the instant case, though this court deprecates and reprimands the conduct of the council, no cost is imposed.
Without any disturbance from any corner, your lordship, and we are paying the revenue regularly. The issue arose, your lordship, when on March 2024, order for demarcation came up, your lordship. There is a land, beyond the petitioner's land, at a foot of the hill on the government land, there is a cremation ground which is used by the Srihati village. Suddenly, without the knowledge of the petitioner, a road is being constructed over that land, and that road has encroached 3 katas of land of the petitioner without giving him any notice. When this came into his knowledge, your lordship, he approached the executive engineer PWD. He did not serve him notice, did not reply to the petitioner. He then took up the matter to Sir Commissioner and Secretary. He made 3 representations regarding this, your lordship. One with the Commissioner Secretary, then Chief Engineer PWD Road, and District Commissioner Kamrup. Lordship, in the 3 occasions, his representations were not answered by the concerned department, concerned authorities, your lordship. Then he took up the matter.
Construction done,
Construction is on the way, your lordship.
going
Going on, your lordship.
on your land.
Yes, your lordship.
Notice, yes, madam. When?
P das. Can I pray?
When, madam? When?
1 week time will be done.
Notice making it returnable on 19th of August, 2024. 19th you are available.
Yes.
Embalmment accepts. Chaudhary appears on bill. And Rustam Khan appears on behalf of the department on call. Taking into account that the council, the respondent number 2, 5 are duly represented, is served upon them during the course of the day. As regards the respondent number 1, the counsel for the petitioner is given the liberty to, is directed to serve a copy upon a standing counsel of the Revenue Department. The case of the petitioner herein is that the petitioner is a owner of a plot of land measuring
3 bigha. Your lordship.
3 bighas
Yes, sir.
covered by
Patta number 109, Dag number
Dag
936.
number 936 and included in KP Patta number 109 of page Spanpara, Prabhat the district of
Kamrup rural.
Kamrup. It is the case of the petitioner that the respondent authorities, without following the due process, have encroached upon 3 kathas of land
Acres of land.
belonging to the petitioner and are constructing a road
Yes,
road,
yes, your lordship.
constructing a road. First, the petitioner have represented with the respondent authorities, more particularly the respondent number 3, time and again. However, no actions have been taken to demarcate the land as to whether any portion of the land of the petitioner have been encroached by the respondent authorities in constructing the road. Under such circumstances, the petitioner has therefore approached this filing the instant writ. On the returnable date, that is on 19th August 2024, the councils appearing on behalf of the PWD as well as the District Commissioner, Kamrup Metro, Kamrup Rural, shall apprise this court as to whether any portion of the land have been and portion of the land belonging to the petitioner have been encroached. This court further observes that this court further the interim order so sought for in the instant proceeding shall be considered on the returnable date.
Right, please, your lordship.
Yes, what are you challenging?
My lord, here, my lord, the 25 lakhs, my lord, per kata has been sought to be given to me, my lord. And I have objected saying that market price should be given to me, my lord.
Huh?
And market price, my lord, should be given to me. That's my objection, my lord.
In
So
respect
we
to what?
We received the notice, my lord, and thereafter we have filed our objection. And then, my lord, through RTI, my lord, we have come to know that my lord will find page 21, my lord. Page 21, para 3, my lord. The valuation of the land has been fixed for 20.
Now, you were asked to appear on 30/12/2023.
We appeared, my lord.
Then what happened?
We appeared and we filed our objection, saying that the valuation of the land is much less even than the zonal value. And the zonal value, my lord, will find, I have managed the zonal value also. Zonal value is 48 lakhs
Then
per kata, my lord.
have they passed the award?
No, my lord.
Huh?
My lord, they have fixed, my lord, 25 lakhs per kata, my lord. And I have filed an objection saying that per kata 25 lakhs is much less because the land is a fast food plus land connecting with the 80 route, my lord. We are near Kamakha Gate and we are having our business establishment also there. Our residential houses are also there, my lord. And my lord, we have any the zonal, at least we say that let's about the market price because market price should have been given along with the multiple and all these things. But even the zonal value, my lord, that is 48 lakhs. And we have been given, my lord, sought to be given 25 lakhs. It's almost half, my lord. That is zonal value. In the 80 road fast float, my lord, 25 lakhs, having a residential place, business place, my lord. That's our. So our
Award has
PR
been
is, my lord,
passed or not?
Our
Award has been passed or not? Award has been passed or not?
They have not, my lord, said it. They have not passed anything, my lord, on save and accept the notice, my lord. Save and accept notice, my lord, nothing has been, no information, nothing of this. And our, my lord, petition page 17, my lord, fine. And notice, my lord, page 16, we have received the notice, my lord. And after getting this page 16 notice, my lord, we have filed our complaint, my lord, that page 17. And thereafter, my
No,
lord,
but
they are
Mr.
sitting-
Chaudhary, appreciate one thing. If you are agreed with the amount, you have to therefore make a reference application. Not before this.
My lord, that's right, my lord. Your lordship is right, my lord.
You can take the money under protest This court is not going to adjudicate how much it is. I can't do anything.
The lordship is right, my lord. The only, my lord, their own notification, my lord, journal below.
Whatever may be, you show it to them. Whatever they do it wrongly. You can very well ask more. And for that, the authority categorically says that the act categorically says that if there is an enhancement, you are going to get interest at the pay rate of 9% and 15%. If they give it wrong, you are to file an application. Before they are, this is a case of reference. This is not a case of by which this court is going to do it, because the moment I do it here, it will be nothing. This court cannot come up at the end of the day, this court cannot decide that you give him 48 lakhs or 50 lakhs or 60 lakhs. That would be interfering with their wisdom. The act gives the power. 226 is not for that purpose.
Where, my lord, case 17, my lord, that our, my lord, complaint, my lord. After
That
receiving.
is why, Mr. M.H. Chaudhary, I therefore asked as to whether the award has been passed. This is done under the Assam Land Acquisition and Acquisition Act 1964. You will see section 12. Have you got that act?
Yes, I
See
have.
section 12. Alright. Acquisition. Take on.
461,
Section 12.
my lord, section 10.
What does it say?
But it says, my lord, where any person agree by an award made under section 3 of the section 11 makes an application regarding the market is to be referred to the court, or where there any disagreement, here my lord, disagreement with regard to the compensation payable under subsection 4 of section 11 on the application of the person entitled to compensation, requiring the matter to be referred to the court, refer the matter to the decision of the court. So here, my lord, we made an application, my lord. We made an application and that
This
to
is
be
after the
referred.
award. You can't file it beforehand. That is why my question to you was whether the award has been passed. Now kindly see, this has to be read in conjunction with section 11, section 18 of the Land Acquisition Act 1894. Now if you see Acquisition Act, all these things can be very well taken note. Then why should this court interfere or exercise a writ? This court can't do that.
For a moment, my lord.
Hmm.
For a moment, my lord. Please 16, my lord.
Yes. So I think the compensation has been done. The award has been passed. Now go and file. You file a fresh application under section 12 for seeking reference. Better off. 12 read with 18. And the right to fair compensation as regards. M.H. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner. But Mr. M.H. Chaudhary, the learned senior counsel, behalf of the petitioner, appears on behalf of the PWD department. Ms. S. Sharma appears on behalf of the Commissioner, Kamluk Metropolitan. None appears on behalf of the Revenue Department on call. taking into account the order which has been, which is this court proposes to pass, this court doesn't find the necessity of the hearing, the presence of the respondent number one is dispensed with. The petitioner herein is aggrieved by the
Page 16.
what do you say? 94. By the inadequacy of compensation given to the petitioner in respect to the land which have been acquired by the respondent authorities in LA case number 29/2023. This court is of the opinion that taking into account that there is an effective and efficacious remedy available under Section 12 of the Assam Land Requisition and Acquisition Act 1964, which is to be read with the Land Acquisition Act 1894. For arriving at an appropriate compensation in terms with the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. The petitioner herein would be well advised to approach the district commissioner seeking a reference to the court as regards the inadequacy of compensation, as well as also, do you have any problem with the land, area of the land?
No.
No, inadequacy of compensation. Subject to, however, the petitioner receiving the compensation under protest. Accordingly, you have taken under protest?
Yes, we have.
Yes.
Please, my lord, 17.
70?
17.
We are under protest to Nelly. Accordingly, this court is not entertaining is not inclined to entertain the petition. However, the petitioner is given the liberty to approach the respondent number two, respondent number two, who is also the collector, taking a reference in terms with Section 12 of the Assam Land Requisition and Acquisition Act. 14. Yes, Mr. Davula. Yes, tell me. What is this? POSCO and all, what this court have to do with the POSCO thing? Yes, tell me. Properly investigate into the matter as per law and as soon as possible complete the investigation without unnecessary delay.
Our grievance I started in para number 3 and 4, page number 5, your lordship.
Yes, what is it?
Lordship, the accused person moved under offense scale, lordship, used to threaten us. Your
Case
lordship.
has been registered? Investigation done?
No, there is no single attempt on the part of the respondent, especially the Sapur police station, lordship, to arrest the accused person.
When did the incident happen?
Didn't happen, lordship,
Registration done?
done, your lordship. This number 15 is the FIR, your lordship.
Incident happened is that on 10/6/2024. Then you do under 156(3), why haven't you got?
Actually, the police never visited the field. There is no any single attempt on the part of the police, especially the.
But why are you not approach the concerned magistrate? Why should this court interfere? What is happening?
found
If they don't do it, then very well, we can very well take it under 482. But no business of this court under 226.
Your Lordship, we found
The law is very clear, Mr. Counsel. Sakira Basu. Can't help it. Versus State of UP.
found difficulty to move outside your lordship due to threat of the accused person, your lordship.
Huh?
Due to the accused person used to threaten me and my family, your lordship. That's why, lordship.
Then why you are not informing them, informing the police
I
that you have
proposed
been
to the-
threatened?
Lordship, I also filed a representation to the Director General of Police, NXRP page 17, your lordship.
Where is that?
Page number
That you have
17.
asked that there is a threatening. Not a single whisper. They are not arresting him, that is another aspect.
Lordship.
But you are not saying that you have been threatened.
Lordship, para 4, your lordship, I started, your lordship.
What do you say?
Para 4, lordship, as last part, your lordship. The family member found difficulty to move outside from home out
Where,
of
where?
distance visit from the all accused person.
So, page 17,
No, page 5, your lordship.
page 5?
Para 4.
No. Here. Or moving here, you can say many things. Have you moved the authorities? Tell the authorities that look here, I need protection. Ask for the protection. Is a proper machinery available? Why should this court entertain 226?
In the meantime, may I pray for a direction to the SP, your lordship.
Huh?
May I pray for a direction to the SP to file a representation, your lordship, by stating our grievance, your lordship.
Why should I issue a direction to the SP? You want to file, go and file. You are always at liberty. SP office is always there. Then, what to do? Go under 156(3). 156(3) and look into this, the serious matter there. Heard Mr. A.A.R. Karim, the learned counsel appearing on behalf of the petitioner. S. Sharma appears on behalf of all the respondents. The case of the petitioner herein is that the petitioner had lodged an FIR which was registered as support PS case number 107/2024 dated 8/7/2024 under section 365, 342, 376/34 of the Indian Penal Code, read with section 4/17 of the POSCO Act, corresponding to GR case number 309/2024 at Sopor in the district of Dhubri. It is the case of the petitioner that the respondent authorities have not taken any steps to properly investigate the said offense, investigate the said crime, and have also not taken due action against the accused. Under such circumstances, the petitioner had also submitted a representation to the respondent number 2 for taking due action, which however have not been taken. In that view of the matter, the petitioner has approached this court by filing an instant writ petition. The law is well settled by the Supreme Court in the case of Sakira Vasu, State of UP, State of UP versus Sakira Vasu, reported in 2008 to SCC 409, which is also followed by various other judgments of the Supreme Court, that a writ petition ought not to be entertained in view of the express provision under section 156(3) of the Code of Criminal Procedure 1973 being available. Under such circumstances, this court would not like to entertain the instant writ petition. Be that as it may, the petitioner herein would be at liberty to approach the jurisdictional magistrate under section 156(3) of the Code of Civil Procedure, Code of Criminal Procedure 1973. If the petitioner is aggrieved by the investigation so carried out by the concerned officer in charge, concerned investigating officer of support PS case number 107/2024. It is however observed that in such circumstances, if the petitioner files such application, the concerned magistrate in accordance with law, files such application in accordance with law, the concerned magistrate shall duly consider the same in as per the extant law. The above petition stands disposed. Yes, Mr. Ganguly.
Limited prayer for disposal of my appeals, my lord, against the suspend orders passed. by the-
Appeal,
Yes,
got a
Appeals.
stay. No stay.
but I have a prayer for stay.
Be happy.
The fact remains that there are two appeals. One appeal is filed on 18/10/2022. Other filed on, my lord's,
If you have got a stay, then why, what is there?
no, stay. As of now, because my lord, the ITO is issuing me a notice for recovery of the penalty amount.
No, you have not got a stay before the appellate court. Why?
So this is the NFAC, my lord, the CIT appeals, National Faceless Center, my lord, that
Huh?
National Faceless, my lord, Assessment Center, FAC. At the moment, in fact, my lords, in my second appeal, there is not even a date fixed. I have submitted the written submissions, they have acknowledged that my only limited prayer, these two appeals may be disposed of, one way or the other. They may decide in accordance with law. They cannot, my lord, keep my appeals pending and also, my lord, coverage of the penalty. That they cannot do, my lord. And I have also annexed the guidelines.
How will he inform anybody that appeal is to be reached, after all, faceless?
Faceless, no, that is the difficulty. We have made the
No,
representation.
that is not the difficulty. This type of orders, it becomes helpful for the SSC to identify who is the faceless person.
But we have made our representation, my lord, on 9/10/2023, as far back as 9/10/20.
Isn't there?
That is the difficulty. We are faceless, but we also do not know whom to approach.
So it
all
becomes
we-
very, because how, tomorrow whom will they file a contempt
That is correct.
unless you identify him? And once you identify him, that is the problem. The entire faceless thing goes for a six.
That is for the department to sort out. In fact, this matter was dealt with similar matter. I could when representation. Filed. Such guidelines were issued last year, my lords.
Hmm. What happened there?
There were some peculiar cases, my lord. What happened in that, in one case, apparently there was a hearing of a faceless matter.
But don't you think, irrespective of that, the powers given to the appellate, the CIT appeals now is faceless. Now, CIT appeals includes the power of stay.
Yes, lordship, it is there.
If the power of stay is there, then what is the problem?
So the power of stay, my lord, the fact remains that we have been asked to deposit 20% at least of the say that we are in no position to pay, decide our matter one way or the other, so that we have our remedies in law. And even as per section 256A, my lord, the CIT appeals is supposed to decide the matter at within 1 year of the end of the financial year in which, my lord, the appeal is filed. In this case, my lord, the first appeal that I have filed.
Then what happens? What is the consequence? Not
consequence-
deciding the appeal.
The consequence is not mentioned there in section 250, which describes the procedural aspects. It is not, but 256A does describe the time limit. And in fact, the government's own guidelines are there, which also have annexed.
Section?
Where 256A subsection 6A.
But you're referring to which section?
Not to section 250 subsection 6A.
Every appeal, the commissioner here, where it is possible, may hear and decide such appeal within a period of 1 year from the end of the financial year in which such appeal is filed for him, and under subsection may make a scheme by notification greater efficiency here. Now, how a person would be heard in a faceless appeal?
We have already submitted our written submissions, generally passed based on that.
When did you submit your written submission?
The written submissions in the first case, my lord, we have submitted on 26/8/2023.
26?
Yes, 26/8/2023. This is in relation to the, my lords, appeal filed on 18/10/2022. Letter was issued, my lords, from,
26/8.
yes, 26/8/2023.
Then
Then, my lord, no date has been fixed.
another
The other one, my lord, I have instructions, though that, written record, I have taken instruction. That, my lord, written submissions we have filed on 9/5/2024.
9/5
9/5/2024.
earlier. Oh, 9/5.
9th of May 2024. These are filed, my lord, generally after.
Then why should this court, then it is only in 9/5, 1 year is still left. The other is also 1 year is left.
1 year from the, after the appeal is filed. Appeal is filed, my lords, in the first case on 18/10/2022.
No, it says 1 year from the end of the financial year in which such appeal is filed.
Yes. My lord, if your lordship considers, my lord, the appeal against the assessment order dated 20/09/2022. That was filed on 18/10/2022. But the financial year would, my lord, end.
If possible,
31st March,
may
year
hear and decide such appeal within a period of 1 year from the end of the financial year to which such appeal is filed. From the end of the financial year in which the appeal is filed, it is not from the time when the appeal is filed or the period of for which year it is being filed. Just for example, the financial year is of 2017-18. The order is passed by the assessing officer sometime later in whatever maybe in maybe a reassessment proceedings have happened, and thereby an appeal has happened out there. You want to file an appeal, then how can it happen now?
Kindly have page 29. That is the first appeal that I have filed. From 35. This was filed.
Appeal?
Page 29, Annexure 3. Regarding assessment year is 2021. Appeal is filed on 18/10/2022.
So end will be 2023.
1 year has passed. Here in 2024.
Date
the
of
financial year-
e-filing is so and so from the last date
End of the financial year in which the appeal is.
in a period of 1 year from the end of the financial year in which such. Right. The end of the financial year will be from 31st of March 2023.
Sure, yes, 2024.
So you are to finish up by 31st of March 2024. That is the delay. And what is the second one?
Second one, my lords, is not covered under 256A, but I have annexed the guidelines, my lord, of the government, my lord, for priority hearing in cases
Where
involving.
is the second one? Where is it? Appeal?
Second appeal. That is at page 52 onwards.
Huh?
52. Assessment year is, my lord, 2018-19. Appeal was filed 10th April 2000.
10th of April 2023. So it will 24. Then how is it
I'm
possible?
not- In this case, I am not saying 256A covers me.
In this case, my lord, I am relying on the guidelines of the government, which I have annexed at page 81 onwards. For
81
priority hearing.
on- Because this year, the guideline, this
Yes.
doesn't there. And this particular for Annexa five appeal,
For annexure
the
5 to
provisions of
56,
section
will
two
not apply.
fifty-six, six A does not apply.
No, that,
Why?
that will not. But the guidelines of the government, my lord, which I have annexed it.
No, why it would not apply?
Because the appeal is filed in 2023, 10/4/20. So the financial year has ended on.
No, not on that. I'm saying if 256A, has it been amended? 1819. 1819, now if it is, has it been amended? Because this income tax act, this keeps on being amended. This was inserted in 1999. Okay, I don't think it's amended. Then what guidelines you are saying?
My lord, page
The
81.
guidelines cannot overreach the provisions.
Expedite my appeal.
Is
because that-
so and so allow the remand and where
because, it page 81.
supersession of remand and to set a priority of the often remand of pending appeals, we have decided that request for so now, on the basis of this particular document at page 82 and clause Roman 3, you want to invoke bypass
No,
256
no, no,
6A.
not on Roman 3, my lord, Roman 1. Cases where the
Roman?
demand is above 1 crore. In both my cases, the demand is more than 1 crore.
May be considered
But-
on the basis of recommendation of the remand in the following situations. Now, have you approached this
Yes, we have approached.
principal CIT so and so?
Yes,
Where?
page 78.
So and so request for stay of the demand. Appeal filed under so and so. Now, where's the recommendation?
There's no recommendation.
So you are against the recommendation, not for early disposal. Without the recommendation, how do you bring the guidelines?
Them to make the recommendation. I cannot.
Understood. So your case has to be on the basis that there is no recommendation.
My case is very simple, my lord. On one hand, they are pursuing the penalty proceedings under section 274 and other sections. The other hand, they are not disposing. I'm not saying I have a right to, my lord, disposal pay of the penalty, but at least I have a right to, my lord, play.
Mr. Ganguly, one has also to be very clear on this. This court cannot pinpoint out. One has to also keep the faceless appeal in the faceless mode.
Yes.
So under such circumstances, one has to also, therefore, this court is looking into it, why it is necessary, how to take care of it, because tomorrow you are going to file a contempt. If it is not done, how do you do it? Against whom? Whom shall I direct? Because can the principal CIT have a control? Can I say that once he gives a recommendation, if that person does not do it, would it amount to contempt? Kindly appreciate that. One has to also take
That is
note
correct,
of.
my lord. But the fact remains that, my lord, whatever has been said at page, my lord, 80, as far as the recommendation.
That is subject to a recommendation. Now, the recommendation has not come. So, if you are against the non-granting of a recommendation, it is another aspect of the matter.
Well, it is both ways, because the recommendation also has to come from the principal CIT. I have done my part. I have approached the principal CIT by way of a recommendation. I have pointed out that, look here, the penalty proceedings are initiated against me. Take the demand, and my limited fear is that, my lord, my appeal should be disposed. That is mentioned, my lord, in my representation at page 17.
They are paying for all.
Yes, except one.
You notice making it returnable on how much time for getting instructions?
Week's time, 1 week's time will be sufficient.
You notice making it returnable on 21st of August 2024. The DAS appears on behalf of the respondent. It appears on behalf of the respondent number. And appears on behalf of the respondent number 2, 3, and 4. Extra copies of the petition be served upon the learned counsels during the course of the day. The case of the petitioner herein is that the petitioner agreed by the assessment orders passed by the assessing officer have preferred appeal before the Commissioner of Income Tax Appeals. Where's the other one? The second one?
Second appeal.
The first one I've got it at page 52. The other?
Oh, the page 52 is the second one.
And the first one?
Page 29.
Agreed by the assessment orders passed in for the assessment year 2020-21. And 2018-19 have filed 2 appeals on 18-10-2022 and 10-4-2023 respectively. The total demand in the said appeals is rupees 5,76,70,814. Admittedly, there is no stay to the said demand by the first appellate authority. The grievance of the petitioner, insofar as the appeal filed on 18-10-2022, is that in terms with section 250 bracket 6 capital A, the commissioner bracket appeals is required to dispose of the said appeal, decide the said appeal within 1 year from the end of the financial year in which such appeal is filed. It is the case of the petitioner that in the said appeal, the financial year ended on 31-3-2023. And as such, the appeal ought to have been appeal filed on 18-10-2022 ought to have been disposed of on or before 31-3-2024. Next. As regards the other appeal filed on 10th of April 2023, the learned counsel drew the attention of this court to a guideline issued by the Central Board of Direct Taxes, Department of Revenue, Government of India, wherein it has been mentioned that cases having a demand of more than 1 crore on the basis of a recommendation issued by the principal CIT oblique principal CIT bracket central oblique CIT bracket IT can be expeditiously heard. In that regard, the learned counsel appearing on behalf of the petitioner referred to the representation submitted on 10/10/2023 to the principal CIT and however, it is the case of the petitioner that no recommendations have yet been issued. Under such circumstances, being aggrieved by the delay in disposal of the appeal so filed, the instant writ petition has been filed, seeking appropriate directions to the concerned authorities for an expeditious disposal of those appeals. Mr. S.C. Kyle, the learned counsel appearing on behalf of the Income Tax Department submits that these appeals are being dealt with in term by the respond number 3.
Yes, Lord.
Respondent number 3 as it appears from the case made out by the petitioner. As such, he would obtain necessary instructions as to whether those appeals have been disposed of, as well as when such appeal can be at the earliest disposed of. List accordingly.
Okay.
Correction.
Yes, what is this?
A late husband of the petitioner got purchased to the village Madhurya. And it was Kadipatta land. And
Now what has happened? It has been made Sarkari.
it made Sarkari. The last resettlement, perhaps in 2009, the entire Dag is shown as Sarkari Dag. Therefore, already a mutated land is also shown as Sarkari now.
Your land is shown as Sarkari.
The thing that happened was this, the old Dag number 34 has been split into 60 Dags.
Patta number 1.
Patta number 1.
Where?
Madhurya village, and this is in
How much land you had?
the total 3.5 kathas.
Huh?
Kathas first and then 1.5 kathas.
So you had total 3.5 katha, 3 katha 10 lectures
Separately,
in
separate only.
tag number 34 or patta number 1,
Adjoining plots,
page number 3.
it's number 3.
And this land now has been shown as Sarkari in the settlement operation. Now, why you are moving the writ?
To remove that error.
Understood. Why not the authorities? Have you approached?
Found out that the main petitioner, who was the late Mr. has passed away.
He passing away doesn't mean that the
The last annexure showed a notice also.
no. When have you approached?
June 1st, first it was approached, the first application itself is lost. But then thereafter a detailed application was made to the 1st June, 2016, that's Annexure 9.
Then a notice is issued. Kaushik Deka. You are Kaushik Deka.
Wife of Kaushik Deka and son and daughter.
Kaushik Deka died.
Passed away last year in pursuit of this.
Is issued in the other one to appear in the court of the undersigned with relevant records in the original for hearing. 4-4. Then what happened on 4-4?
The Mondal report has been filed erroneously.
Huh?
The Mondal report was filed erroneously. Before that, the circle officer, the Mandal, everybody is giving reports without mentioning the settlement bit, without mentioning that duct number 34 has been split.
Understood, but then also a proceeding is going on there.
So the proceeding has ended.
Where is that order?
The appeal order of RTI is showing that it's just pending without any consequence.
Where is that order in respect to this proceeding at page 162?
And nothing was received after this.
Huh?
This notice was issued and he attended was given to him after.
After you don't know what happened.
Spoke to the DC and they said, we'll do it, but nothing happened after.
Thereafter, nothing happened.
No order was passed, nothing. Nothing happened to our knowledge.
I think we should limit ourselves to this only then. There is already a proceeding. Why should we have two parallel proceedings?
But there's no remedy left for this family now.
Understood. The remedy is this, the notice.
The notice.
You have
we
appeared.
attended.
What has happened there? Let us ask them. What has happened there? Because this was the land which has been purchased by you. And if you have purchased, where this land has gone?
Where is this land is gone? And it is also showing in the land records our name.
And if they are to look
Previous
into the
Jama
map out there, the earlier map, and this map, they are to see it from the trace map and find out. I don't understand. Anyways, we'll take it up at 2. See at page 152. What is it at page 152?
The relevant portion of this online Jamabandi that we get.
So there your name is there.
Yes.
Then
And then it is not reflecting as our this thing. The Jamabandi shows.
where it is to be reflected?
The Jamabandi shows the 2 kathas. The first 2 kathas that we got mutation from in 1999.
How much land has not been shown?
1.5 kathas, but even then this Jamabandi also, although it shows the record in the department shows as government.
Huh?
Sarkari.
What's so time?
Despite showing in the Jamabandi.
How can there be different things, record of department be different?
My lord, and that is the whole dispute.
You have typed out this thing, let us see.
These are all translations, my lord.
Let us see what is there in the this Montabba column at page 154. Where is your name shown?
In 155 it shows, but this
Horidra Hutra Potadorar Goswami Stolot Anpotadar Logot Sri Kaushik Mohanto Peter Kora Hot. Where?
only this first column it shows, my lord, in 51, that's page 155.
Huh?
Page 155, number 51.
No, that is okay, but how does your name is inserted out there in trade? You are asking for 3 katha 10 lechas. Where is it? Earlier it was mutated in your name.
Here, only this Jamabandi was taken out in 7 February 2023. And
Where is it for the first time shown that your land has been mutated in respect of 3 katha 10 lechas?
that, no, it's not 3 kata 10 lesa altogether. It's 2 kata.
Okay, 2 katha and 1 katha 10 lechas. Where is it?
The first Jamabandi is Annexer 14. madam.
Page 93. This 2 katha is being shown.
Kata.
Then, where is another 1 katha 10 lecha?
That was never mutated.
Ah, there the problem lies.
Applied for the mutation. That's when it was
Madam, I tell you one thing. I've done so many cases with this patta. I know where your land is also. I can say
that is
your land would be near the Racquet and Billiards Club.
not that far from there. Yes, the Gitanjali apartment.
Yes, nearby there. Yes.
And so it's this application was, I mean, they deferred the matter because settlement was going on. They deferred
And
the matter.
your land was never mutated. This
That
1
one-
katha 10 lechas. Then why didn't you approach during the settlement proceedings?
Then,
Where? For getting your name mutated, let us see which is your application.
We have next step.
Huh? Where? There has to be a mutation application file.
And
Where?
deferred it to the.
Show me.
The list comes in, my lord. So
Huh?
it's, the first mutation.
Yeah, that I got it. 2 katha is there, and therefore 2 katha is appearing in the recent Jamabandi. You are concerned with 1 katha 10 lecha. Where is that?
1 kata 10 lesa, we annexed it, my lord, but I'm just being a bit.
Prepare your matter properly. We'll take it up some other day. Find out. That is not there.
Annexed.
No, it is not there. And where is your mutation application? Because you cannot, by way of a representation, ask your name to be mutated.
Made an application and they deferred it for until the next settlement, my lord. And I'm just,
No, there is no mutation done.
there's no mutation done
Well,
about that.
you should have,
Deferred it up-
madam, you should have either approached the settlement office at that point of time under 53A. Where? 53A application is where? Is the matter on 14/8/2024. Prepare your matter properly.
Obliged. I'll take your instruction.
Yes, Mr. Shivaru, what did you find? You are okay with this? At all?
Two lines. Instruction. I did get some.
লেখক। Heard Mr. D. Das, the learned senior counsel, assisted by Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner. T. Borua, the learned standing counsel, NHI, appears on behalf of the respondent number 3. Mr. J. Roy, the learned senior counsel, appears on behalf of the respondent number 5 and 6. Mr. A. H. M. R. Chaudhary appears for the respondent number 7, and Mr. R. K. Dev Chaudhary appears on behalf of the respondent number 1. This court, taking into account the issue involved, have passed an order on 6/8/2024, making a particular query. The dispute involved in the instant proceeding has also been clearly delineated in the said order. Under such circumstances, the said order dated 6/8/2024 is reproduced hereunder. Pursuant to the said orders passed, Mr. Siborua, the learned standing counsel of the National Highway Authority of India, had obtained instructions as to whether the undertaking so given by the general manager of the respondent number 5 would be in accordance with clause 2.2 of the appendix 1 of the guidelines issued by the Ministry of Road Transport and Highways dated 26/6/2020. During the course of the hearing, Mr. Siborua had produced before this court an instruction issued by the project director, NHAI, in the form of which was sent to the counsel for the respondent number to Mr. Siborua, the learned standing counsel of the NHAI. Taking into account its importance, the contents of the said email is reproduced hereunder. Saror Assamul. From the above quoted reply so given by the email, it transpires that the undertaking so given by the senior general manager of the respondent number 5 is in terms with clause 2.2 of the appendix 1 of the MORTH guidelines. Under such circumstances, this court disposes of the instant writ petition. The counsel appearing on the senior counsel appearing on behalf of the respondent number 5 and 6 further submits that the respondent number 5 and 6 would be bound by the undertaking so given. The learned senior counsel appearing on behalf of the petitioner further submitted that he has no objection if the in principle approval as well as the in principle the has no objection if the due permission is accorded to the respondent number 5, 6, and 7 for setting up of the retail outlet, provided the undertaking so given is duly complied with. Under such circumstances, in view of the consensus arrived at by the amongst the parties, this court therefore disposes of the instant writ petition with a direction to the respondent authorities, more particularly the respondent number 3, to process the necessary in principle approval as well as the other one is that
Here, my lord, first we will give them,
in principle approval as well as the permission.
no, here is approval only, first we will give approval, thereafter they will construct all these other norms will fill one, thereafter only NOC will fill them. And there in similarly, for petitioner also, though we have given in principle approval, but there also some works have been-
Nobody is questioning
That is
them.
why after completion of this.
Nobody is
norms-
questioning. They are nothing to do with the later because the
of
2.2, the exception clearly says the later will do it. Later is there.
No, because you have to pen, stay by this letter, state that they will go for asking for NOC. Because they are also petitioner also having, they have not fulfilled entire norms, though we have given. That is to be also.
I am not passing any order for them. I'm only passing an order
Acha.
for him.
Lordship will dispose in a petition.
Yes, no, I have nothing to do with them. I'm only asking him that you will only give
Yes,
the
yes.
in principle approval
Yes,
as
yes.
well as
Yes,
the
yes.
NOC,
Nothing should come out for him.
NOC to
My
the respondent number 5, 6, and 7. Via shall provide the NOC in principle approval and the NOC
NOC after that, my lord, lastly.
only upon due compliance with the undertaking
Yes.
so given
And other norms,
as well as the other norms,
NOC will be granted.
and which should be in consonance with clause 2.2 undertaking so given in which is and in consonance with clause 2.2 of the appendix 1 of the MOT guidelines and other norms.
Yes.
The above the petition stands. You are not asking for approval. I'm not asking. So why should I pass?
Earlier interim order may be vacated.
What is the interim order?
But is it
Not to commission the
not to commission?
So taking into account the above directions, the interim order passed earlier has been rendered redundant.
Now 48.
Oh, yes, where is the other people? Yes. Railway? Yes, you are also railway.
Yes.
Railway, yes.
In port number 3.
Huh?
Some leg in port number 3,
Who?
RDV.
So,
I am placing this is a letter issued by the district authority to the deputy chief engineer regarding that page number 1. The page number 2 is a reminder, Lordship. Yes. Then page number 3 is the reply from their side, Lordship. Page number 4 is the letter addressed to the additional district and session judge, Lordship, as because challenging that LA case. They have approved the district and session judge. Accordingly, Lordship, the original record was sent there. Accordingly, it was then next, this is the letter from the solicitor to the additional district and session judge to the district commissioner Amin Gaon, Lordship, whereby that because of the jurisdiction, Lordship, it was sent to Amin Gaon.
No, I don't understand what is all these things. First of all, his land has been acquired.
No, may I please, Lordship? They have stated only the check number and the amount. The whole record is missing now, Lordship, which is not available with us because of all these reasons. So we are asking from them that show us the details of this statement, that it was credited, debited, this bank statement from them, Lordship, the accounts branch. That's because nothing is with us, whether that check
You
is.
will have the records that you have paid it to the petitioner.
No, that
No,
original
no,
record.
you see, we need two facts. Whether did you acquire the land of the petitioner? Yes.
Yes,
Did you pay to the petitioner?
that is according to them, no, we have no records because of these reasons. So accordingly, we are asking from them, show us so that we can, whether it is given to him or not, we cannot say.
Who has disbursed it? You.
Yes, Lordship, disbursing of, no, Lordship, whether that check is credited or debited from their account.
I'm not concerned whether they pay or not. For
No,
you,
Lordship,
no, we need only one thing. Whether you have paid to him.
that record is not available with
Why?
us. That is why, Lordship, if it is credited to us, that amount is credited to us, and according to their claim that it is not paid to them, we will pay them. If it is not credited to
So
our
you mean
account,
to say, the moment they say that they have paid it to you, irrespective of if he only says that he has not received, you are going to pay. Should I record it?
Lordship,
You say that if they say the amount was paid to you, and he only says that I have not received because he can't give negative evidence,
no, Lordship. I am
then
not
you,
denying
no,
it,
then you are going to pay it to him, irrespective of the records.
Lordship. That is why we are asking for the records from the accounts from the railway. As because in their account, Lordship,
Honestly, the railways may say, yes, I paid. Then what is the next course of action?
so Lordship, in that case, the onus lies upon them to prove.
Understood.
That is
Let
why
us
only
assume that they
much,
have paid.
Lordship, only
But
that
have
much.
you
Why they
said,
are
no,
not
have you
giving us?
said that you have not paid? See, there's a difference. You are to say that he has not paid. Have you alleged that the railways have not
We
paid?
cannot, that's because the record is not available with us. That is why, Lordship. Otherwise, had it been there with us, Lordship, the matter would have been settled at that time itself.
No, because of the action on the part of both you and railways, why is the petitioner suffering?
My Lordship, I am just asking from them, from the accounts branch, they show us that detail so that if it is credited to our account, immediately we can pay him.
No,
If
they
it is
will,
not yet debited,
they will not pay vis-a-vis one patadar. Was his petitioner's only land acquired or was it a cluster of land acquired?
Lordship, I am only concerned, but I have not seen the other parts, Lordship, that's because the
No, I'm asking you, then why is that a reference case? Did you file a reference case? No, because he has not filed.
yes, Lordship.
Then it has
There
to
are
be in respect to a cluster of a case. And if that being a cluster of case, they will only give you a particular amount which we have deposited
Lord.
in terms with your requisition. Then how will you know that you have paid to him? Or that they have paid in reference to
Lordship,
this?
if we get that account details, Lordship, it is as because it's not my personal money, Lordship. That is why, Lordship, I am. That's because the record is not available with us.
Better if you don't have the records with you, return the land. Return the land. Take over the land. I've given you permission. Give over the land to them. You are not in a position to find out that, then give over the land. Better off.
Because if their accounts runs, they can. very
Mention
well
that a
give it
dark
to us,
number
Lordship.
so and so patara, but in the Jirat book prepared during reassessment of the Iman of the railway jointly of the year, is a dark number 1046 is government land which was occupied by Sri Horidas Kolita, son of Iman, father of Iman, and the land was acquired in the year 1988. Then how the claimant produced Jamabandi copy of land of dated Iman as well as dark number and some other names also seen who were occupied the land, namely Jayaram, Kolita and so. It feels necessary to mention that dark number 10 was acquired not in whole of the trace map and the Jirat enclosed. Was acquired in LA Krishna by further KRA Iman. Kindly come to page 42, the affidavit filed by the railways. However, the railways have already deposited the amount
Yes,
of
Lordship.
Jirat estimate submitted by DC amounting to rupees so and so by check number so and
Yes,
so
Lordship. Yes, I
and the
have.
railway office number so and so. Due
We are
to
only
unauthorized occupant, the whole of the double line of AI is held up at this location. Due to this, the complete section from AI cannot be commissioned.
Yes, Lordship. Because of why, Lordship, we are only
you get this
asking
money?
for that
Did you
bank
get
statement.
no? Did you get this money?
Lordship, we are unable to say because of that original record is missing, Lordship. That is why, Lordship,
No,
we are
there's a
asking from them.
specific date.
We are asking from them, that is that bank statement. That is why, Lordship. Had it been tested today itself, Lordship, within 4 or 5 days, within 2-3 days, it can be disbursed to the petitioner. Only that much, Lordship. As because no record is with us.
Where's the award?
What that? And they are not also providing us, Lordship. That is the difficulty we are facing.
Your name is what? Bolen Kulta.
Volunteer.
Solen Kolita and Santi Kolita.
Deepak Kulta.
Kolita, total 5 petitioners. Solen Kolita, Deepak Kolita, Rupak Kolita, Solen Kolita and Santi Kolita.
Now tell me, this is not a Were you given any settlement? Huh? You were in government land. What were you paying?
We paying Khazana also. Page number 17, Khazana receipt.
Aruna is the news name.
Polen Polita.
And down below, car pora poa hole, car babe poa hole.
Maybe Judith also.
Huh?
Thus maybe Lord.
Then this doesn't show that you have a receipt for Horidas.
Horidas, yes. Page number 19 Horidas and page number
And
17.
who is Horidas?
Father of Bolan Kolita.
How can Hori Kolita? Horidas Kolita is the father of Iya. The Horidas. This is in dark number. Sir Exona 35. But why did you wake up so late?
File representation earlier.
No, representation, you can't keep on filing for 17 years. The acquisition happened in 1988.
2007, Lordship.
What? 2007. Acquisition happened in 1988
88.
because they deposited the money in the year 1992.
You're paying Khazana till 2007, Lordship.
Yes, you see, that is, this land was already acquired. If it was required, then how can we pay? If it is a part, that is why I asked for the award statement. Mr. H. Sharma, kindly listen. You see, if you see the affidavit filed by the railway department,
Yes.
they say that this land was acquired. Then how did the question of issuance of a patta arise? Prior to 88 or 1992, when was the award passed? If the award was passed, the moment an award is passed under section 16, the land vests in the state with the taking over of the possession. So once the possession has already symbolic or whatever may be, the possession is already taken, then the land has already vested on the state. And if it is vested on the state and if it was the government land at that point of time, because you see what is being given to them is an exona. When did this exona come into being? Whether there is any documents to show that it was prior to that. Because the government categorically says that this exona, the railway said that this was never an exona earlier. Where is the question of patta and all? This is the government land. And therefore, it is the payment of was only for Jirat compensation. They never said about the payment of land compensation. Under such circumstances, if that is the land which is there, then where is the question of payment of any from them? That is why they have woken up so late. See, this is how they are making in this case, because why they are approaching after such a from 1992, they are moving now. You see the contents of the petition, if you see it. Yeah. They say that in the year 2007, the petitioner's land was acquired by the respondent for construction of the railway tracks for Guwahati Jogihopar railway line. If this be so, then why the payment was made in 1992? What is your reply?
From the affidavit of the railway lordship, it is the Jirat compensation.
Obviously.
Yes.
No, therefore they say it was all along a land which was a government land. And therefore we paid the Jirat in 1992. Now, what is your reply as regards this KRA station? You kindly see that the petitioners have mentioned that this his land was acquired by so and so, whereas the village Tejpur, Moza, Rampur was acquired in LA 29/88. Further, KRA is used by the Deputy Commissioner Office of Air, which was established in the year 2009. So the claim is not proper. So therefore, the petitioner has come much late. Now, they say that it was in. What notification is this? Show me this notification. This paragraph 3 of your petition. What is this notification KRA? How can a land acquisition notification be under KRA? It is always under LA.
Kindly peruse page number 23. From here, we found that KRA number.
No, KRA cannot be a land acquisition. Page 23. What is this? This is some letter written by somebody. Report in the context of so and so video, I hereby state in email, made an inquiry on the same. After the inquiry, it has been found that the railway tracks are running through a portion of Exona Patta land covered by Iman of a plot of Iman, but there has been no proposal for acquisition of the same. No compensation has been paid after a joint inquiry. Nobody knows who circular officer has written how. Your answer to this, the answer is, what is this? Reference is KRA 47/2007. The question therefore arises is as to whether there was at all any land acquisition now. Yes, they may be entitled to Zirat, that is another aspect of the matter. Or whether they are at all entitled to the Zirat or not, that is another, that is different aspect. But the question is, if this land was already acquired, where is the question of petitioner getting any compensation for the land?
They are asking for the.
They will ask many things. Tomorrow they will ask that the moon has water, kindly let the government give some water from there. I don't want any water from the municipal authority.
I will
They may
clarify.
ask many things.
Lordship.
That has no relevance. The question therefore was specific. He does not say in under what acquisition proceedings, because KRA cannot be an acquisition proceedings. And it seems your official must have done all the problems. This letter of Annexure 4 is the problem.
Lordship.
There's no otherwise any problem. Why the petitioner have woken up after such a long time? 1988, the acquisition is being done. 1992, payment of Zirat has been made. Obviously, you may not have the records for the last 30 years. Why has he approved such a long time? Why? What is this type of letters out here? KRA. KRA has no business out there. Which is the LA case under which it is acquired? You don't know. Then do you have any letters, document to show that prior to 1988, you had any land? The land was in your name.
A certified copy issued in the 2009, Lordship, which we have LA.
No, not 2009. Prior to 88. Then?
Presently, I do not have it, Lordship.
Then?
I have to ask them.
If you had, because what happens once a notification issued under Section 4, there is no question of devolving of any interest or rights over the land. Has the government filed the affidavit, the circle officer?
No, Lordship.
Why? You are going into another point, which we are not bothered with that.
Lordship.
The question is answered. You have to give an answer to what they are saying as well as read the affidavit filed by them
Lordship.
and file an affidavit. Because that document is creating the entire problem. That is Annexure 4. Who is paying for the railways?
Lordship.
Isn't that?
Yes,
That is the case.
yes, to be developed later on.
Yes. Acquired land has already been acquired in the name of the government, the central government. It has been done. Land has been given, everything has been done, now this has happened. And what does he say? Kindly see this document at page 22. There's a road being, there is a railway line which is going on. And this line which is being going on and there without proper, this is the letter of which is the basis of his case.
Lordship.
And the creation of the problem is none but Mr. H. Sharma. Yes. Also, Lehok. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. H. Sharma appears on behalf of the district administration of Kamrup Rural. And Mr. R.K. Dev Chaudhary appears on behalf of the railway authorities. The petitioner herein has filed the instant writ petition claiming compensation in respect to the land which have been alleged to have been acquired in respect to a plot of land belonging to the petitioners which have been taken over, alleged to have been taken over without following the due process. On the other hand, a perusal of the affidavit in opposition filed by the respondent railway authorities shows that the lands in question were acquired in respect to LA case number 29/88. And in that regard, due payment was made to the DC Kamrup Guwahati amounting to rupees 12,63,469 by the check number 020-132/0003 dated 6/1/1992 by the Railway Office letter of even number 204 dated 31/1/1992 for village Tejpur.
May I clarify, Lordship? Yesterday, one affidavit was filed on behalf of the district commissioner, but that is regarding only that payment part, Lordship. That
No, we are not.
Lordship, that is why I'm just pointing it out. The detailed affidavit will be required.
However, it is seen that the entire basis, the edifice of the petitioner's case is on the basis of a document issued by the Circle Officer, Polasbury Revenue Circle, dated 25/5/2007, wherein it has been stated that Dag number 1046 contains a total plot of land measuring 4 bigha 3 kathas, and there was no proposal for acquisition of the same, and railway tracks were found running through the portion of the said land. The reference made to the said application, to the said in the communication, is some document bearing KRA 45/2007 dated 15/5/2007. Taking into account the specific case made by the people stated in the affidavit filed by the railway authorities, whereby it has been stated that the land had been acquired as far back in the year 1988. The respondent district administration is directed to file an affidavit as to whether the acquisition proceedings which were initiated in terms with the acquisition proceedings so initiated in terms with LA case number 29/1988 included the land which is the subject matter of the instant writ petition. This court further finds it very pertinent to observe that the petitioner herein have not been able to show any document prior to the initiation of the acquisition proceedings being LA case number 29/1988, wherein the petitioner or their predecessor in interest name were recorded. The respondent the DC, Kamrup Rural, the District Commissioner, Kamrup Rural, is directed to file an affidavit in that regard. To list the matter again on 11th of September 2024. The affidavit be filed by the respondent district administration by 9th of September 2024 without fail. Which on the payment later on will arrive. In addition to that, this court shall also hear on the maintainability of the incident with petition on the ground of delay and laches.
17 also same. Petitioner's late father was one of the co-patators.
What?
At that time, he did not have next of kin certificate after applying the next.
Same, LA case.
Same.
Yes, Mr. H. Sharma, where are you? Come here only, you take.
Same, একেটাই হয়, খালি co-patator মানে হয় আৰু।
Yes, same land.
So this one affidavit will cover this one also.
Issue notice making it returnable on 11th of September 2024. Miss R.K. Dev Chaudhary appears on behalf of the respondent number 1 and 2. N. Bodlo appears on behalf of the respondent number 3. The H. Sharma appears for the respondent number 4, 5, and 6. As all the respondents are duly represented, extra copies of the writ petition be served upon them during the course of the day. This court duly takes note of that the case involved in the instant proceedings is similar to the writ petition. Similar to the case involved in WPC number
8426, 2022.
8426, public 2022. This court by an order today dated Aji date have sought for certain instructions from the District Commissioner, Kamrup Rural, in the form of an affidavit. Any decision rendered in the said writ petition would also squarely cover the instant dispute. Accordingly, the instant writ petition be tagged along with WPC number so and so and listed accordingly.
Much of it.
Yes, Mr. J. Kolita, what is this?
Cases that is petitioners.
All for the records, issue notice why mandamus should not be issued, particularly to show cause as to why the petitioner shall not use and register the name Golak, name of the who is to approve?
The circle officer for registering the society, one report to the circle officer is necessary. Initially, the circle officer.
We issue notice, nothing more than that. Notice making it returnable on 13th of September 2024.
I am appearing 5 respondent for respondent number 6.
6.
I'm the cabinet of it.
Who appears for this firm and societies? You appear? Ms. S. Sharma appears on behalf of the respondent numbers 1, 2, 3, 4, 5. The so and so who also a caveat who also appears on behalf of the respondent number 6, who is also on caveat. Taking into account that all the respondents are duly represented, extra copies of the writ petition be served upon the learned councils by tomorrow, date to be removed. The case of the petitioner herein is that the petitioner has a right to use and register the name of its society as Golokganj Municipal Fish Business Committee. However, the respondent number 5, at the behest of the respondent number 6, is not permitting the petitioner to use the said name. Isn't it?
Subsequent,
Huh?
initially, that's it. He favored us, he has issued the speaking order in favor of us. Subsequently, respondent number 6 approved this honorable court, and this honorable court again also remanded matter to the circle officer, stating that this order may be passed. So on the
Your
basis of-
case is 5 is in connection, collusion with 6,
now the 6.
taking into account the above. This court, full stop. Thank you, Lebo. The case of the petitioner is that the petitioner is entitled to use and register the name of its society as Golokganj Municipal Fish Business Committee. Initially, the petitioner was allowed to use the said name. However, on an objection being filed, an objection was filed by the respondent number 6. Pursuant thereto, an order was passed on 25/8/2021 Pursuant thereto, who approached?
That is the respondent number 6.
The respondent number 6 approached this court by filing a writ petition, which is WPC number 318/2012-22. The said writ petition was disposed of by an order dated 30/8/2022, thereby directing the circle officer Golokganj Revenue Circle to pass a fresh order within a period of 1 month from the date of receipt of a certified copy. By taking note of the objection so raised by the respondent number 6 herein in its representation dated 13/8/2020. Pursuant thereto, the order was an order was passed on 21/6/2024, whereby the petitioner was directed not to use the name Golabganj Municipal Fish Business Committee, isn't it? But are you registered?
No, we are supposed to register, let's say, the process for registering. The process for registering and.
But how are you filing it like that?
Initially, as per this order, speaking order dated 21/6.
But if you are not registered, how are you maintaining it?
But since they have approached initially first, they have approached us on the basis of that their repetition, this honorable court directed to pass speaking order, and this speaking order was passed also. Lordship is pointing out the correct question that how this case is maintainable because they are both are not registered. But initially they have approached this court, Lordship, because on the basis of this order of the honorable court, they have passed the speaking order.
Understood. But tell me,
Lordship, I
how
understand,
are
yes.
you
I
approaching
understand,
if that
Lordship.
name cannot be used?
That is their killers, not us. That is their grievance, Lordship. There is.
No. If you see in the speaking order, as of now, you are not registered. What is your status to approach this court as a writ petitioner?
For registering our society, we approach the circle officer to.
Understood
Because
everything, but
are
only
not-
thing is, what is your status to move a writ?
I understand, Lordship, that, but has they have approached the court, they are also not registered. So they are-
Fantastic, but I am not going to review that order now.
Since the circle officer has registered.
I am not on that. My specific query is today, how are you approaching this court?
The circle officer order, we are basically challenging. it.
No, understood, but what existence you have? You have been asked not to use. You are not registered. But tomorrow, this petitioner has no business.
So Lordship, basically that to form a Lordship society, there has to be some purpose.
Huh?
So we are having some purpose, Lordship, we approach the circle officer that we are doing this kind of business, this kind of voluntary services, so we may be recommended for registering our name. Accordingly, Lordship, circle officer issued an order in a favor of us, stating that they are doing this kind of voluntary activity, so their name may be registered. That order was challenged by the Lordship Response number 6. And this honorable court has taken cognizance, Lordship, on that petition and issued the order.
Mr. Koilta, you are again going back to the same thing. I'm not on that. I'm asking you, how do you file this petition?
As a Lordship, secretary of this petition number 2, as a secretary of this Lordship society, though it is not registered, but we have processed, Lordship, applied for us. Thank you, Lordship. We have
How many members you are having?
all members, Lordship, have not annexed also.
How many? You are challenging an order that you cannot use a name, and by using that name,
We are not,
how is it permissible? Tell me.
Lordship, we are not fully restrained, Lordship, they just, the circle officer just suggested this petitioner not to use the name. Lordship will find the page number 32, the last line.
Huh.
Last line, Lordship, I am reading.
May use
respondent
different
may
name for
use-
performing any kind of activities or for any kind of registration anywhere.
We were just suggested, Lordship, not directed.
Then why are you aggrieved?
Because Lordship, otherwise, Lordship, the circle officer will not issue any report which is necessary for registering our farm. To register a farm, Lordship, circle officer report is necessary. Lordship. And Lordship will find the first report, it was forwarded, Lordship will find at page 24.
Last line, ठीक? Pursuant thereto, an order has been passed on 21/6/2024, which have been challenged in the incident proceedings. This court directs the respondents to bring on record their stand by filing affidavits on or before the next date. This court, however, keeps the maintainability of the writ petition open.
Alright.
Yes, madam, what is this?
Fact, my lord, after filing of this, some development took place, so, some instruction from the petition.
982, where is that order? 18.7? Is that order, madam?
Order, my lord. Annexure eight.
Where is the Honorable High Court in so and so with the direction he had to give an opportunity to petitioner issue necessary order in the matter in the court. Yes. What case you have?
This is regarding allotment of the market counter, my lord. Initially, the petitioner was given allotment by order dated 11/3/2015. So, my lord, after getting the allotment, my lord, he has, my lord, deposited amount of 20,000, my lord, as security deposit. That was also accepted. That on.
How much did you pay?
My lord,
How much did you pay?
20,000, my lord.
Okay,
That
you
is
return back.
Annexure C.
Turn back the 20,000 matter over. What else? For the 20,000 you need
No, my
all
lord.
your life.
Subsequently, my lord, there was a direction of this honorable court. Take a hearing, my lord.
The
and-
hearing done,
and
you see,
lord,
the problem is they have already given that land to the railway authorities.
My lord, but there is a.
That
space,
is a
my lord.
public, that is the, that is
Available
the,
space is there, my lord,
Huh?
inside the campus, my lord. There is a parking lot, my lord. That is.
what business you are
that is
doing?
The, my lord.
Oh,
inside
madam,
the
what business are you
campus of
doing?
ASTC, my lord.
Huh?
Inside the campus of the ASTC, my lord.
No, no, what
they
is your
said,
business?
My lord,
And run the
cannot
ticket
inside
booking
that,
counter
my
for small commercial vehicle till dismantling of here without giving even. Ticket booking counter. Have it somewhere else. You have no right.
My lord, because initially they were given allotment, my lord, and it was cancelled without giving any notice, my lord.
What?
Without giving, your lordship may kindly see annexure, my lord, D at page 23.
You were given a final order after hearing. They cannot give it to you.
My lord, after filing of this petition, my lord, the petitioner informed me that there was some development has taken place. So, my lord, I am waiting for the, my lord, instruction.
Fantastic.
So, my lord, it may come. up
Cancel
Monday,
appearing on, because you see, this development will be there for 1 month.
My lord, I have not received any information right now, my lord, but
1 month.
my lord, it may come up on Monday, my lord.
No, Monday, again it will come back to me. We need a 1 month.
No, my lord, in the morning also I mentioned the matter, my lord, regarding the instruction.
Yeah. Council appearing on behalf of the petitioner seeks for an accommodation. This the matter again on 28th of August 2024.
Thank you.
Your lordship, my lord. As per section 30. We have in the matter.
About to prevent discharge করে দিব দে itu আগৰ Yes.
My lord, as per section 34, that within bracket 4, if the audit reports are not submitted, then the directors cease to exist their post. Now, lordship may kindly see page 30, subsection 4. of the Cooperative Societies Act, all directors shall cease to be directors on the date of the annual general meeting. If the annual financial statement of accounts and annual report of activities for the previous financial year were willfully not prepared before 15 days of the annual general meeting for inspection of the members or for placing before the general meeting, then all the directors shall cease to be the directors. So 2002, 22, 23 and 22, 23, 22, 23 and 23, 24. These 2 years audits were not prepared, balance sheets were not prepared, profit loss, etc. were not shown. In such a manner, my lord, I requested the directors. I am the president of the Bagmarathon GP. I requested them that please do this. But already 26 lakhs rupees have come to the society, madam. Only to grab that amount, they brought the no confidence motion against me under section 36(4) of the Cooperative Societies Act. And that was passed. Then I filed appeal before the registrar under section 36(5) that I have been ousted in an illegal manner because I want that the AGM should be held, audit should be reported. But the members want to get that money, and that's why they have brought the more than 6 months. Time is 5 years, 4.5 years already passed. I am a very good man. All of a sudden, I became a bad man when this 26 lakhs rupees has come. Now, as per section 34, subsection 4, there is no board at all. There is no board at all. But the register, my lord, did not look into this matter. Kindly go to section 34. And
Are we on the question of there is a board or
and
no board?
report lordship.
No, no, Mr. Mahmood, are we on the question of board or no board? Or are we in the question that the resolution which was passed, the order which was passed on 25/7/2020 is right or wrong?
Both the things are coming here. There is report, my lord.
No, no, no,
Of
where
the
have you
auditor.
mentioned? Let us see your case. You are only asking for stay of that order. If there is no board, why should you be unhappy?
My lord, no, that is 2 matters, my lord, that I have managed Alexa a page.
No, 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 no.
Element.
What is your, let us see your relief. The relief which you have sought for out here is as to whereby the petitioner have been removed from the post of chairperson shall not be set aside and consequential follow-up action as so and so and so. On one hand, you say that there is no board, then why should you be the chairman? Take it up that there is no board. Take up with that matter. That is not your
Para
case.
11, Candice.
Take up your case in a different manner. You cannot say that I should be retained as the chairperson when you are submitting that there is no board.
There is no board because I
If
want,
there is no board, then why are you to be a chairman?
I am not a chairman
Okay,
in that.
then you have no quarrel with the order of 25/7.
No, there is 2 matters. First thing, my lord,
The
whether
relief is
the-
only one.
page 13, para 8 can listen.
No, 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 nothing.
Yeah.
The relief is only one. Mr. Mahmood. Relief sought for is only as regards this order of
It is on
25/7.
record. I am saying the kindly see page 51, the report of the inspector. Report of the inspector. Page 51, bottom. Kindly see here, many things have been discussed. Then page 51, bottom, since 28/9/23 till the date of inquiry, that is on 6/4/24, 4 Board of Directors meeting have been held. On the Board of Director meeting dated 16/10/23, proposal number 6 stated that Ripon Ali Sarkar Secretary will present the internal audit of 23/22/23 and 45 days in Board of Directors meeting. The Board of Director meeting dated 19/11/23, the Board of Director proceeding book is written incompletely. The Board of Director meeting dated 10/12/23. No decision regarding the internal audit was taken. The Board of Director meeting dated 8/3/24 was adjourned due to lack of quorum. Overall, there was no decision taken regarding holding a special general meeting as proposed in the AGM dated 28/9/23. As per the above mentioned documents and annexes, we come to conclusion that as per the minutes of the AGM dated 28/9/23, no internal audit was presented. And in order to fulfill this agenda, no special general meeting was called for by the Board of Directors. Hence, this inquiry will be submitted to you for you to do the needful as per Act and provision of law. We beg pardon for the slight delay in submission of this inquiry report due to involvement in various activities of parliamentary Lok Sabha election. Now, hence, inquiry report is submitted. Inquiry report is submitted, my lord, before the assistant registrar. Assistant registrar is keeping silent. And as per section 34, there is no board. I told them to first take the audit report. There is public allegation. My lord, may kindly say public allegation is there that you kindly see now page 40. Public allegation.
Have you challenged the meeting resolution adopted on 15/4/2024? Where?
Actually, that is in my appeal.
Well, it is challenged in the appeal. Have you got any interim order there?
In appellate court. That I have, I
Have you
have
got
not
any
noticed
interim order?
That was heard, but entire order of impugned order is illegal because kindly see page 31. Impugned order,
Why?
31. A petition was submitted on 22/3/24 by Sri Pavitra Ravidas and 531 others. So this is the most illegal thing, because a president or chairman may be removed by the board of directors. Here, 531 persons, how came? So register did not apply his mind mail. How Pavitra, sir, he is not a member, he is not the director. And 532 persons altogether, how they come? It is the, after all, if there is something by majority votes, I may be ousted. But thing is this, my lord.
You were
here-
ousted as far back as on 15/4/2024.
Yes.
So what is wrong with this order?
First wrong is this, my lord. 531 persons, how they come in the.
Anyway, let us issue notice. Nothing more than
And my
that.
lord, this 26 lakhs they are drawing. So
No.
that is the main thing, my lord. I want to save the public money. That is why I,
You save the public money, go to the register will help you out.
register
You-
it is with the knowledge of register.
Let them do it, but this is not done. Take money, you save it, file PIL.
Basically, my lord, on the face value of
Notice.
the impugned order is
Who is
illegal
there?
because-
Yeah.
So regarding this 26 lakhs, my lord, some observation may be made by. Otherwise, this public. money-
Observation, no, if I have to give some observation, this case is for dismissal on the right one. This court has to dismiss because the order is absolutely right, taking into account that on the basis of the resolution passed on 15/4/2024, you have already been ousted.
No, on that day, there was no board, my lord.
No, but you have not challenged that.
I have not said-
Mr. Mahmood, you have not challenged it. You have challenged it somewhere where there is no order being passed.
Approach the matter before the assistant registrar.
Very good. You have approached that. There is no interim
So I am
order.
not sitting idly. I am going here and there.
Okay, issue notice.
And this is.
You want the notice or a dismissal, either
No,
of
I
it.
want notice, but
Only
this
notice.
amount should be saved, but.
What? No saving amounts. Saving amounts is not the business of this.
No, it has come to the,
Why should I save amounts when it is not your case of your case? It is none of your case.
in the,
Are you seeking that relief, Mr. Mahmood?
specifically mentioned, they want this money.
Mr. Mahmood, there is two options I am giving you. You want a notice or a dismissal? Either of
The
them.
notice may be same.
Only notice.
Resolution and matter may be disposed of the next day. We have no objection.
You will see when
The
it
thing
is.
is this, my lord, amount, because of this money,
No, nothing.
these
doing.
all things
No,
are going.
nothing doing.
So I think
To
I have brought
notice.
the matter to your notice.
To notice making it returnable on 11/9/2024. so appears on behalf of the secretary, who is appearing?
Secretary is a private party.
You are appearing,
6 to 50.
who is appearing for 5?
Private secretary lordship.
The BC does, the learned senior counsel. Along with, assisted by so and so,
At least so.
represents the respondent number
6 to
6 to 16.
15 lord.
Who is 16? 16
16 is his secretary lordship.
is also the secretary.
By name here.
15. Pusto. Taking into account that the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition be served upon them by tomorrow, date to the. As the respondent numbers 5 to 16, 5 and 16. Will. You want an early disposal?
Well, yes, I want. But private respondents have appeared through my learned friend.
5 and 16 is not there. Is given the liberty to take steps upon the respondent number 5 and 16 by way of dusty. It through the registry of this court and file an affidavit of service on or before the next. Herein have assailed the order dated 25/7/2024 passed by the Register of Cooperative Societies, whereby the resolution dated of the Board of Directors dated 15/4/2024 passed against the petitioner, thereby removing the petitioner from the chairmanship of Bagmara Char SS Limited under under the provision of section 36(4) of the Assam Cooperative Societies Act 2007 was approved. On the returnable date, the respondents are directed to bring on record their stand by filing their affidavits. Pass an order. And if he does not, I can't help you, you take that plea.
No, it has gone on record. It is already on record.
On record, so why should
Your
I
lordship
again
has
say?
passed an order. The access copies will be given.
Excellent.
21, 22, 23, and 25 are connected. Unless the facts and issues involved in these 4 petitions are exactly identical to the matter which came up before my lords last Friday, which is the 2nd of August, where my lords had passed the order, which I'll just pass on. Identical facts, because my lords, here also, the mining lease was cancelled. My lords, we got to know only when the affidavit was filed before this court. And those in the first one, these matters are also there, my lord, just to point out the similarity. And while
Same.
same, my lords, yeah, same date, dates are same, my lord, dates of the orders are the same. Mining lease also executed on the same date. We got to know also on the same date by these affidavits, my lord. So we prepared a chart, my lords, for my lord's convenience. I could just hand it over, which will give the dates to my lord so that my lord sees the identical how the things have moved. Then my lords, I could take my lords through each of the petitions of my lord pleases. First, my lords will kindly turn to serial number 29, the set of events which have happened, wherein the affidavit filed by the additional affidavit filed by the state in the pending writ petition in the first round, we got to know that there's a cancellation order. Then my lords 29, 30 onwards, my lords, we've turned to the other side saying that these
In the earlier cases where the writ petitions were there,
writ petitions are there, my lords. My lords will kindly see the orders are there at page 25, my lords, serial number 24 and 25. Orders are annexed, identical orders. My lords, I'll point to the pages also. serial number 25.
See, on the last occasion, if I remember, I put it on a very limited score.
Yes, my lord will kindly see the scope, because my lords, this is the same case where my lords, we were not heard and the cancellation orders were passed. My lords will kindly turn to my lords, para 11 onwards, which is at page 4, bottom of the page of the order. Para 11 onwards, my lords. And then my
These
lords
are
will-
all graphite.
graphite. And then my lords will kindly turn to, yes, all graphite, my lords.
But the areas are different.
Areas are different. They are different mining leases, my lords, for different areas. And my lords will kindly see para 16 onwards, what my lords have put to me. Is para 16, my lord. Para 16, 17. And 18 is the interim order. That is
Mr. NNB Chaudhary, can we have this again on 29/8?
29/8/2000.
Because the earlier matter, we are having it on the same day. It is the same set of facts. All have been cancelled on 14/7/2022. All have filed writ petitions, wherein all some removal orders that there was some order which was passed that was stayed, but be that as it may, I have only passed an order to that effect out here that there shall not be creation of any third party rights till the next date. And only thing is as to whether section
5(2).
Section 4A, my lord, subsection
4
B.
483.
My lords have noted that.
483 of this act is required to be followed or not, taking into account that these people were not heard, and as to whether any notice was issued at all to them for hearing. That is the only limited scope. Because what you did is on 14/7/2022, you cancelled all these licenses, all these leases. You informed by filing additional affidavit in those writ petitions. But you also say in a subsequent letter that we have issued it, but it had not gone to you. But we cancelled it on such and such date. And therefore, they have approached this court. The limited intake prayer, although they asked for stay, I made it only to the effect that no third party right should be created out there. So that it will be there only till the next date. So as the facts are almost same, there's nothing out there. We pass similar orders out there. Only change the name of the council.
My submission may be recorded, what has been submitted. by
Instead of Mr.
Guswami.
B.D. Goswami, I will put your name.
And another than there is a notification, my lord,
For what?
or High Court, my lord, matter may be transferred to Arunachal Pradesh, my lord. Because these notifications.
No. These have been done with the permission, administrative permission of the chief.
Yes, I have granted the permission, my lord.
Ah.
Normally, what Honorable Justice M. Monish Chaudhary, my lord,
Hmm.
one day asked me, my lord, only for motion purpose and admission purpose, matter will be taken here, my lord. Because, my lord, what is the administrative power? There is no third perception. I have gone to the letter, my lord. Nothing is available. Only my duty to point out this notification, my lord. I point out.
Matter anyways is on a limited point, can be disposed of at the, not the admission stage.
No, you see, the permission was granted
Yes, sir.
by the Chief Justice in view of a similar matter pending before this court,
Pending.
Yes, sir.
the principal seat.
Right.
So if that permission is given on that basis, it would not be proper on my part to send it.
Hello, sir, it's absolutely correct. Whether only motion purpose or for the whole purpose, permission has been granted, my lord. Normally, my lord, only for motion purpose, the permission has been granted. Otherwise, other matter may be transferred to the Arunachal Pradesh also, my lord. It's my duty to point out, my lord.
No, wait. Where's the, yes, no, here. Allowed to file it the, yeah, to file it.
Only filing, my lord. And motions.
So it has to be here.
Yes, my lord. I leave it to you.
During the pendency of the aforesaid an additional affidavit was filed here, it is stated that the cancellation purported to cancel the executed license issuance. I am going to pray that your lordship may grant the permission to file and move the area pertaining to the area in my lady.
Only to file. I leave it to your lordship.
Now, you see, if it was a court which was not able to take it there and as such moved out here, the question of remitting the matter from here would be justified. But the reason why it was moved out here, taking into account that there is a pendency of the earlier writ petition here, that is why. But I think, Mr. Sharma, don't you think those other writ petitions also should be brought
Yes.
and tagged out here?
Earlier repetitions, my lords, we also, there also, my lords, special permission was taken.
No, I'm not there. Whether those writ petitions also should not be brought out here, taking into account that that is the basis on which you are moving.
I will have to analyze the order, my lords, that my learned friend is relying on.
No, I'm not on that.
Yes.
Not this thing. I'm saying when your basis of moving the application is because of the pendency of the earlier writ petition, don't you think that the earlier writ petition also should be
Yes, that's
listed before this court together with these? Because then only it makes sense. Otherwise, what was the sense in moving the application here if you are not tagging the other matter with this?
In fact, my lords will be able to peruse the records of the earlier petitions also, so that might help also, my lords. can bring
Because
it
the
across.
earlier petitions were against the respond number 3.
Yes, that IBM, my lord, that is why we filed it before this court, it's based in Guwahati, my lord.
Now, have you made the correction here and
Yes,
made the?
definitely, my lords, we made the correction as per my lord had pointed it out rightly, my lords, we made the correction, my lords will kindly.
Now you have made here, na?
Yes, the
Respondent
secretary,
number.
my lords will kindly see that at page, my lords, 3.
No, here, why haven't you? This time also you have not corrected it. In these repetitions also, I would have understood earlier you have made a mistake, but you can't keep on making the same mistake out there. I've made it a point that you should have made the secretary a party.
Done that, my lords, kindly
Where?
page 3.
Page 3
my-
what? It
kindly
is
see
still
page
the state of Arunachal Pradesh, Union of India and Indian Bureau.
New secretary, my lords. My lords, last time in the last petition, we said director, my lords had pointed out the anomaly and we've corrected, my lords. Made it through the secretary, in all the 4 petitions, my lord.
এখনত এটা কাম কৰিব ন একে অৱৰা হ'ব এই paragraph
My lord,
number
another thing is that, sorry,
Yes.
another thing, my lord, the party is Scamot Mining Private Limited. And if let's say go to page 56, P1, my lord, the order to Stenos Cement Private Limited, my lord.
What?
You will also kindly go to the my lord, petitioner who is Scamot Mining Private Limited. And I know that. Then you will also come to page 56, my lord, annexure 1.
56.
Yes, my lord, annexure 1.
Hmm.
Stenos, grant of prospective license for graphite over an area at Taliha in West Upper Siapanse district AP. And if your lordship go to the prayer portion, my lord, they said in respect of La Lamdak graphite mine, page 53.
My lords, if there is some error, we'll point out, but the other, my lords will kindly see the main orders, they are correlating with the.
Page 201.
P3,
Hello?
my lords.
201.
Yes, sir. 209 is correct, my lord.
Okay, এইটো এটা কাম কৰক হা এইটো অৰ্ডাৰটো চেমেই হ'ব খালি নামটো টি শৰ্মা হ'ব হা NNB চৌধুৰী Additional Advocate General.
Yes.
Union
Yes, no.
Yes Locker. I'm to Didi. Type for by Goswami Jodha said that in Burma to only নামটো বদলাই দিব petitioner hearing is তাকিটা বদলি যাব হা প্ৰত্যেক graphite আছিল over an area of 4.96 square kilometers আছিল এইটো হ'ল এইটো বদলি থাকিব এইখন কাগজৰ পৰা চাই
কপি এটা পাম নেকি? কপিটো পাম নেকি?
ওৱান ই য'ত লেখা আছে ন ছেক্ৰেটাৰী what
Thank you.
Secretary Geology and Mining, Government of Assam বুলি কৈ দিব হা য'ত ৰেছপন্ড নম্বৰ 1A বুলি গ্ৰাফাইট পোষ্ট দি এইটো ফিক্স কৰি দিব সেইটো আৰু খালি এটাই কাম কৰিব ইয়াত তাহাঁতৰ চিমিলাৰ ৰিপিটিশনছ কিখন আছে ন
Just to point out, Manoj, we mentioned the mining areas in that note also.
Yes, I have seen it. That at number 1, na?
Yes, my lord.
That is
before
La
number one.
Lamdak,
Yes.
Bopi, Tai Tekni,
Yes,
and
ma'am.
other one, no?
Lordship, yeah.
That I have seen it. Which are the repetition numbers?
Repetition numbers are right on top, my lords. Item 21 at the top.
No, not these. The earlier
The
ones.
earlier repetition, my lord, is the item, my lords. This
Oh,
is
yes,
repetition
page 25,
386,
serial number
25.
24 ত আছে দেই প্ৰত্যেকটো analogous repetitions আছে আৰু এই তলত সেইটো একদম লাষ্ট লাইন এটা লিখি দিব list the matter on so and so along with on so and so along আছে 29
গোটেইকেইটা লক্ষণ দিয়ে
চাই ল'ব হা 29
I'm deeply obliged.
Then NB Chaudhary, I think you should make better submissions than these technical unnecessary submissions. You don't expect this.
Otherwise, section 5(2) was not followed, my lord. Without following that, my lord, how can settlement can be made, my lord? There is no rule by the government also, central government also, my lord.
Therefore, I put a question out there
Yes,
in
ma'am.
that order that
Yes, ma'am.
whether an exception will apply out here, taking into account there is no mining lease out there. There could not have been a, and it would not come under section 4A3.
Yes, ma'am.
Find out, file your affidavit.
Yes, ma'am. There are other points also I will argue later on.
Very well,
Yes, ma'am.
but don't argue these type of points.
Yes, ma'am.
Oh,
It is that case, my lord.
which one? Oh, Dima Hasao.
Dima Hasao. We have filed an application for improvement of. the
Yes,
city.
serious on that. Yes, serious, very serious with this. I thought that you would not have liked to go against the CM. Well, I can level.
IA number
This is an
2385.
application filed by Mr. B.D. Goswami, the learned counsel appearing on behalf of the applicant. This is an application filed by the petitioner to implead
They are at page 6, my
the
lord.
chief executive member bracket CM of the Dima Hasao Autonomous Council as the respondent number 6 in the accompanying writ petition being in the accompanying writ petition. To stop. The reason why the instant application has been filed is that the order
At page
was
40.
was passed by the principal impugn order was passed by the principal secretary NC Hills Autonomous Council, Aflong, at the direction of the CEM. Taking into account the above, this court is of the opinion that the chief executive member, CM, who is the opposite party number 4, is a necessary party for the purpose of adjudication of the instant dispute, accompanying for adjudication of the accompanying writ petition. Accordingly, this court allows the instant application, thereby arraying the opposite party number 6 in the instant application as the respondent number 6 to the accompanying writ petition. The petitioner is directed to file a fresh memo of parties before the registry of this court, and on the basis of that, necessary correction being made by Monday. And on the basis of that, the registry shall make necessary correction in the records of the writ petition and file an affidavit as well as also update the same in the CIS. Yes. Your case is this. You have to issue notice.
Grant of my lord administrative, well, that is an annexure F series, my lord.
Will issue notice only. Notice.
The lordship will kindly make it returnable.
Huh?
Kindly make it returnable.
Yes, yes. I am very particular on that. Issue notice, making it returnable on 13th of September 2024. It's the finance.
AG, my lord, respond number 3.
Mr. RM Das appears on behalf of the respond number 4, 5, not 6.
No.
4 and 5.
No, lordship, only 4. 5 my learned.
Why not Assistant with the Development Commissioner?
That is a state will represent lordship.
Appears on behalf of the respond number 4. To stop. The Mr. J. Hendick appears on behalf of the respondent numbers 5. Mr. E. Sharma appears for the respond number 3. None appears on behalf of the Finance Department on call. Stop. It has been submitted by the Learned Counsel appearing in a stop. Yeah. Taking into account that the respondent number 3, 4, and 5 are duly represented, extra copies of the writ petition be served upon them by Monday. As regards the respondent number 1 and 2, the petitioner shall directed to serve copies of the writ petition upon a standing council of the Finance Department of the Government of Assam. As regards the respondent number 6, the petitioner is directed to take steps by way of registry, registered as well as usual. In addition to that, in addition to that, within 3 days. In addition to that, the petitioner is also given the liberty to effect service upon the respondent number 6 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is an executive member of the North Kachar Hills Autonomous Council.
In charge of social
He's
welfare.
in charge of the what department?
Social welfare and Panchayat and Rural Development Department.
Is in charge of the Panchayat and Rural Development Department of the NC Hills Autonomous Council. The petitioner is aggrieved at the action of the respondent number 2, 4,
4 million.
4, who had taken steps, who had passed the impugned order at the dictates of the respondent number 6. It is the case of the petitioner that the respondent, by the impugned order, the fund allotment to the department of the petitioner under the 15th Finance Commission. The 15th Finance.
Commission, my lord, they have, when I say omitted that word, commission, 15 finance.
Under the 15th Finance, what is that? fund allotted to the PNRD department for the year 2023-24 has been kept at hold, which is contrary to the constitutional mandate.
Particularly after my lord administrative approval is granted. That is, it's 21.
More particularly after
Administrative approval have been granted by the same respondent, respondent number 4, madam. And page 21 onward.
administrative approval having been granted on 28/6/2024 by the Annexure F series. Yes, finance, he's there. A. Soliha appears on behalf of respondent number 1 and 2. Before the next returnable date, the respondents shall bring on record their stand by filing their affidavits. The interim order so sought for by the petitioner shall be considered on the next date.
Much okay.
To A. Soliha, 1 and 2. Yes, Mr. Goilda.
May I point out one thing, Lordship?
Yes.
Kindly turn to the page 3, Lordship. Page 3. Respondent number 1, Lordship is given.
What is this?
Understand better to withdraw this petition of
Reserve Finance, Small Finance Bank represented by Commissioner and Secretary Revenue Disaster. Counsel appearing on behalf of the petitioner submits that there are certain formal defects in the instant writ petition, and he may be permitted to withdraw the instant writ petition and refile. Taking into account the formal defects, this court closes the instant writ petition on withdrawal. However, liberty is granted to refile by removing the formal defects.
Please, sir, I'm sorry, really sorry. Your copy paste.
And copy paste has gone haywire. Huh?
Sorry.
Six, order implement of party.
application for implement, my lord.
Hmm?
The applicant is a 85 years old person.
Hmm.
His, my lord, one plot per left. Floor has been, my lord, totally taken away by false deed, my lord. We have applied for the sub-register also. We find that nothing is there, my lord.
What is this? Application for respond number 5. What is the case about?
Yes, my lord, regarding, my lord, the municipality restrained them from making some construction alteration in the floor, my lord. Which is belong to me, my lord. We are rejecting there.
No, what is this? I didn't understand.
And they said that they have purchased it from one Jibon Krishna Parik. Amitabh Bachchan.
Petitioner have stated that they purchased the flat measuring in 1 first floor by way of a registered and after purchase some repairs were service of notice dated. Whose building it is?
My building, my lord. Applicant. And the applicant. And my lord,
Who are they?
my lord, what happened? One, Amitabh Acharji, my lord.
It is something like the that your Anand Jalpan, no.
No, no.
Yes. Tell me.
He's from Dhubri, my lord.
No, maybe, but the facts may be similar.
My lord, what happened? Amitabh Acharji, my lord, is a person, my lord, from whom, my lord, because I took loan from the bank. So there was some default for some purpose, some amount has been taken. He got some signature from me, my lord. it appears that thereafter some prepared some document, but that has been not registered.
Huh?
That has not been registered, my lord.
Sale deed.
Sale deed not registered, because if you also see page 23 of my picture.
No, your sale deed is not registered.
Actually, mine was registered, but my vendors they have alleged that not registered. Actually, not found there, but his name was mutated.
This one is different. But your vendor's sale deed registered?
Not
According to them, not, because we have searched in the Jamabandi Chita, his name was there. So therefore we purchased from him. Now they are alleging that because of him and with his sons, some disputes are there. And that is why he's creating problem to me,
Now, why have you approached this court?
because I undertook some repairing of the building, because this is the old building. Resort. After, during the course of reparation, the GMC municipality has given me a notice to stop the renovation. So I applied. According to them, I do not have permission. So I applied to them, but they did not do anything because of his complaint.
His complaint,
His complaint.
mentioned it.
No, I have not mentioned. Actually, they have also not mentioned. Now in his petition for implement, he has said.
So you admit that it is at his complaint, everything is happening?
No, according to this, my lord.
No.
No. In my application, in my petition, because of this municipalities.
Municipality board has received a complaint,
What municipality?
Dhubri municipality. Dhubri municipality board.
Which municipality?
Dhubri, my lord.
Gubri.
Yes, sir.
And why have you taken action?
My lord, actually what happened, my lord?
At his behest?
My lord, I am for Dhubri municipality board. My lord, we received a complaint on 26 December 2022
From whom?
from Jibon Krishna Kundu, who filed the implementing petition, my lord.
From Jibon Krishna Kundu, him. And on the basis of
On the
that, you have
basis of
taken
that,
action.
my lord, Executive officer, Dhubri municipality board, wrote a letter to the senior sub-registrar Dhubri to inquire about the registered sale deed. As per allegation of the complainant, my lord, earlier it was sold to Bachchan.
Mr. Counsel, kindly come to the point. Did you take action against him on the basis of his complaint?
Yes, madam, that is correct.
Is it or not?
Categorically that is
Okay,
correct.
fantastic. This is an application filed by applicant seeking implement in the accompanying writ petition on the ground that the applicant is a necessary party to the same. Is the further case of the applicant that the applicant is actually the owner of the flat in question, wherein the petitioners have sought for permission to construct and make renovations.
Renovation.
This court also heard Mr. So-and-so, the learned counsel appearing on behalf of the Dhubri municipality, submitted that the municipal board had also initiated the action, taking into account the complaint which have been filed by the applicant. Under such circumstances, it is that the applicant herein is a necessary party to the accompanying writ. Accordingly, the instant application stands by impleading the applicant herein as respondent number
That's now 5.
5 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties by Monday.
Lead petitioner.
But the petitioner, it is your thing in Monday. And on the basis of the said fresh memo of parties, history shall make necessary correction in the cause title of the writ petition and also I'll update the same in the CIS. Instance disposed. Main
Sure.
petition kora diyo.
By
The
Wednesday.
GN Sahewala, the learned counsel appearing on behalf of the newly implemented respondent number 6, 2 weeks time for filing their reply.
4 weeks, my lord.
4 weeks.
My lord, from the sole person.
We are also going to file
4 weeks time to file reply. The council appearing on behalf takes some time for filing the reply. Taking into account the urgency expressed by Mr. Sahu, the matter stands adjourned of September 16th of September 2024. The replies, the affidavits be filed on or before 9 by the respondents be filed on or before November. The petitioner, if so advised, would be at liberty to file reply.
Copy of the writ before maybe.
You are filing without a copy? Don't tell me.
My lord,
This type of submission, Mr. Sayola,
instead of Monday, Wednesday, definitely.
but
That writ petition, amended writ petition.
oh, you are only to, don't have to file an amended petition. You have to only file a fresh memo parties.
Memo.
Only these
Only
names,
that
no
has-
sign, nothing, only the memo. That you have to do. That is why the direction is not to the petitioner, to the counsel of the petitioner. So he took a duta order, a memo.
Then permission.
May I please your
Yes, you wanted time?
hearing?
Wait, where is Miss S. Sharma? Yes, what is your instruction? Yes, what is your instruction?
Not received, Lordship.
So how can it be not received? Every time there is an instruction has been sought for, long time. It was categorically said that as prayed for by Miss S. Sharma, the learned government advocate for the state respondent, list the matter on 9/8 to enable the state respondents to place the update instructions in the matter.
Lordship, on the 13/6/24, my lord, we communicated that, my lord.
They are not informing. Which department?
Lord, this is my lord, regarding the district commissioner Huzail,
Okay, very well. We asked him to be present.
given last chance.
What is this matter about?
Matter, Lordship, this is a government land, my lord, they are seeking, my lord, the allotment that land.
Why is the estate, why is the railway estate officer made a party?
The railway, my lord, earlier, my lord, they serve a notice for eviction, Lordship. They
Then?
said that this is the railway land. Against that, my lord, notice, my lord, they opposed before the, my lord, the learned court below, Lordship. That was set aside. Against, my lord, that, my lord, they approached this honorable court to allot that plot of land to them, Lordship.
But have
Without
they
any
filed?
proper.
No, but have they filed an application in
Nothing,
accordance?
nothing.
How can it happen, madam? Okay. We are not going to go into all these things.
Sure.
You have not filed. The council appearing on behalf of the petitioner shall apprise this court on the next day as to whether any application have been filed seeking settlement of the land as per the applicable provisions of law. So list the matter again on 19th of August 2024. Madam, it's a very simple thing. What you need today as your senior is not there, I'm not troubling you. Here, the only order what can be passed is that you have to go there, file an application either under the Vasundhara portal or in terms with the application in Form 125 and 126. That is the final order you are going to get. So under such circumstances, any delay is in your prejudice. The lands, everything will go. Okay. And if you were there out there, I can very well mention that the land policy would be duly taken. Where is the land?
Actually, I am not in that case.
But tell your senior, whoever it is, somebody have asked you to appear, na? Tell her. Do this. Next time I am not granting any adjournments. Yes, what is this? None appears.
I am not pressing this petition because one.
Not pressing. Mr. Ardor, the learned counsel appearing on behalf of the petitioner submits that she is not pressing, he is not pressing the instant petition. Why?
That is against the same issue, one RSA is pending lordship for year of 2011. But I am not pressing this.
In view of a similar dispute is pending in another writ petition.
RSA lordship.
Huh?
Review petition.
RSA.
A review petition,
Second appeal is pending, Lordship. RSA.
RSC. Taking into account that a second appeal is pending in respect to the same dispute. Taking into account the above, the instant writ petition stands closed on withdrawal. Full stop.
I'm appearing on behalf of respondent number 6.
Give your names, whatever names you want, you give it.
Obliged, Lordship.
Your lordship. Issue is refusal to enroll me as an advocate under the bar council on the ground. Refusal to enroll me as an advocate, your lordship, on the alleged ground that as I was working in a railway, I could not have pursued the regular course, your lordship, which is not correct. Your lordship may kindly see annexure 7, page 28. Relevant is at page 29. 29. File number so and so, perusal of order dated so and so, the letter dated so and so. Release from the principal Borpeta College, which is quoted as below. With reference to your letter, I am to inform you that we could not report any order.
Wait. Where is that?
Page
Annexures?
29,
Annexure?
annexure 7,
Where is that page?
second page, 29.
Peruse the order so and so received from the imam. And discipline to enroll this. What happened?
Your lordship.
The matter was referred to the bar
Referred to the Bar
council.
Council of India.
And
They then ultimately by annexure 11, your lordship.
39, the report, the general house of the council at its area under so and so has constituted. The report dated so and so submitted by Mr. B. Approved. What is the report?
Report
Reference to so
of
and so.
Bar Council of India is at annexure 10 and 11.
Good grounds and Huh? So your enrollment has been refused by the bar council. Why?
They doubted that I could not have pursued the regular course as I was performing service under railway. In fact, I have filed an appeal and also the certificates. I was granted 450 days study leave. Then your lordship, they have stated that I am landing. No, I was working under landing division, but was posted at Kamakka railway station. And from Kamakka railway station, Borpeta is little distance, your lordship. I could have attended. And there was no fixed duty hours. I was shifting duties. Then your lordship, I filed an appeal explaining everything and also this certificate, your lordship. Now, for the moment, your lordship kindly take rule 3 of the Bar Council of India rules. Had I not been have the minimum attendance, I would not have been allowed.
No,
by
no,
the
no,
university.
no, Mr. Nair, tell
Fine.
me one thing.
Fine.
Do you doubt his degree?
One of the degree is not doubted, but that he did not attend because our rules, they lay down that he has to attend 66% of the classes.
No,
No.
then he may not be entitled to appear in the examination. But if he have appeared in the examination,
Fine.
then can you say that because he has not appeared out there, you can divest him from this agreement? Yeah,
Why not?
because this is a LLB degree.
Yes,
Unless you doubt this degree, how can you do that?
why not? We are not doubting the degree.
If you are not doubting the degree, he has the degree, you have to
He has-
enroll.
He has
Can
the-
you say that a person who during his study did not have the required attendance,
Right.
he cannot be granted enrollment?
No, because our basis for the reason, my lord, was that this is a professional course. He has to attend the classes. Now, if my lord comes. to
No, no,
us,
no, I'm not on that.
listen,
My question is very simple.
that he has the degree, since we are not doubting the degree, we have to give him the.
That the law degree has been obtained after undergoing a course of study for a minimum period of 3 years as provided in these rules.
Fine.
That the course of study as in law has been by regular attendance at the requisite number of lectures, so and so, so
Fine.
and so.
No.
This is,
Now, my lord may come to serial number 3 on the next page, my lord,
oh yes.
of this.
The students shall be required to put in minimum amount of the lectures on each. No, understood. This is for the purpose of appearing in the examination. But is this the here for enrollment?
My lord, what we were on, my lord, is, I understand lordship's query, that he has the degree. But what we were on, my lord, is that he could not have attended the regular classes. That is why the.
No,
council
for that he may not have been, he ought not to have appeared, or the authorities should
My-
not have allowed him to appear.
My lord,
But have you taken any action against those authorities?
my lord,
You are all powerful. Why you are not taking?
my lord,
But how can you take away the year of a person who is 63, 67 years
Right.
old now?
my lord, that is why,
Can't
my
do
lord,
that.
my lord, that is why on the last date, my lord, the Guwahati
Who
University.
is the
was,
Bar Council chairman
uh,
who has done this? I
well,
think
this
his
was done by
license
the
needs to
committee.
be done.
This was done by the committee, by the enrollment
It can't
committee.
be like this.
Uh.
There has to be some basis.
My lord,
I understand that person concerned very well. You don't allow him to attend. But what action have you taken against that school or college who permitted that person to attend the examination?
my lord, in fact, we sought for a report from the college. The college says they don't have any record of his attendance.
So then, why haven't you de-affiliated the college?
No,
Have
no.
you?
The problem with us, my lord, is that the Bar Council of India does the, in fact, they do not allow anything on any role in the state bar councils to allow inspection of the colleges. They have taken everything on themselves.
So,
That is, my
that
lord, we are
means, and
powerless that way, my
therefore you would like to exercise your power not to give enrollment.
My lord, on the last date, my lord, the Guwahati University was impleaded.
Not necessary. Unnecessarily, these people need not. 3 years course after graduation. What is this? Is this section permissible limit as regards enrollment?
My lord, for
No.
qualification of the degree, my lord.
Can't be for enrollment. Enrollment is different.
Enrollment is.
This is for standard of legal education and
Fine.
recognition of degrees for admission as admissible. This can't be for that.
My lord. That is for recognizing the degree, my lord.
So do you have to say that you don't recognize this degree?
And we have to recognize, my lord.
You can't do it.
The problem was, we saw that this person
stop it.
was employed, he could not have attended classes. And in fact, he admits, my lord, that
Anyways, at the
Right.
end of the day, he's
I
67 years.
understand,
I
my
think
lord.
you should give him the enrollment.
I understand.
What do you say, Mr.
Yes, your lord.
Yes.
It is his ambition to become a lawyer.
But he has to pass an exam now, no?
Yes, your lord.
No,
Ah.
no, my lord, for pre-2010, they don't require.
Eh?
Pre-2010, they do not require. That AIB is only for post-2010 degrees, my lord.
Because he passed earlier, no?
Earlier, my lord.
Okay.
He passed during his service, my lord.
Do something good.
27.
Heard, Mr.
Army.
Friends, so the learned counsel appearing on behalf of the petitioner. The PD Nair appears on behalf of the respondent numbers
2 and 3.
Two.
2 and 3.
2 and 3. None appears on behalf of the respondent number 1 on call. Who appears for 4 and 5?
1.5,
For
5, your lordship.
Okay, okay.
Yep, one
None
minute.
appears on behalf of the respondent number 1, 4 and 5 on call. First, the petitioner herein is aggrieved by the action on the part of the respondent number 2 and 3 in not granting the enrollment to the petitioner, in spite of the petitioner having a valid LLB degree granted by the University of Guwahati bearing registration number 022852 of 1979-80. The rejection of the petitioner's application for enrollment is based upon the reason that the petitioner could not have completed, could not have passed the LLB examination after prosecuting LLB classes regularly, which is a condition precedent. This court had put a specific query upon the learned counsel appearing on behalf of the respondent number 2 and 3 as to whether the LLB degree so granted to the petitioner is being doubted by the respondent number 2 and 3 who have passed the impugned orders. It is submitted that the respondent number 2 and 3 do not doubt the LLB degree of the petitioner. However, in view of the fact that he could not have attended the course at Borpeta, the LLB course at Borpeta, while performing work as a DRM Lamding, the enrollment have been not granted to the petitioner. Full stop. This could further full stop. Further, upon perusal of the impugned order, finds that without there being a challenge to the degree so obtained, or without doubting the authenticity of the said degree, the respondent authorities, the respondent number 2 and 3 could not have denied the enrollment of the petitioner on the ground that the petitioner could not have attended classes at Borpeta Law College. Full stop. Under such circumstances, the reasons on which the petitioner's application have been rejected for enrollment has been rejected have been found not to be justifiable and reasonable. Accordingly, the same is interfered with. And further, this court directs the respondent number 2 and 3 to do the needful to process the application of the petitioner on the basis of the LLB degree as well as its extent loss. The same be done, taking into account that the petitioner presently is at 67 years, the same be done within a period of 4 weeks from the date of the instant order.
Deep your right.
Yes, give it to you. Something good needs to be done. What do you say, Mr. Sahola? At that point of time, in 1979-80, 1993, how many persons have attended so much of classes in LLB? Huh? LLB was taken, if I remember, when I was studying law, LLB was taken out there in Delhi by mostly the UPSC students because they could pursue their UPSC studies when they take LLB. Then it's not necessary.
Now we are looking at.
Now it's okay. Okay, you are saying about the 1993.
My case also in preliminary, I have also not attended that much.
Huh?
Inter and final, I have attended, but in preliminary, I was getting a different place.
Nobody, because you see, at that point of time, most of the people used to have not got any admission in any other course. LLB is the best resort. Isn't it? Some girl is not getting married, okay, get her enrolled in LLB. No, that used to be the thing. Somebody is trying to get it out there in some MA, they have not got it out there. LLB, next year he will try. Because he need not study. Nowadays, it's become more and more professional. Everything is, you can't incorporate the soul.
Obliged, madam.
Yes, what is this?
Pertains to non-payment of dues of account.
Professional fees.
File our affidavit.
What is your stand? Are you paying?
Yes, Lordship.
Huh?
Yes.
You're paying?
Paid, Lordship. They have taken a very unique stand in the affidavit.
Huh.
This case was, the amount which was due was 3 lakhs. Your Lordship. Now, sanction was accorded for that entire amount. After that, Your Lordship, an opinion was taken from the judicial department. And on the basis of that opinion, Your Lordship, the amount which was payable has been reduced, Your Lordship.
Hmm.
And they have made a statement in the affidavit, which I've just, that they have already paid that amount. I need to otherwise check up if we have received that amount. But Lordship may kindly have a look at the this notification which has been interpreted by the judicial department.
Next, sir.
That Lordship will find at page number 31 at the affidavit in opposition.
No, what is their stand at the end of the
Their
day?
stand is that the amount that
Correction in the statement of Rima was made as per the suggestion of the LR as regards to so and so. As per sanction was accorded of an amount of 40 only for the pay. to her account as per the meeting. Then how much they are paying?
Lordship, against that amount of 3 lakhs, they have paid 1,40,000.
Are you not paying the remaining?
Lordship, their contempt petition, my lord, only 20,000 has been paid to the, my lord, the person who appeared in the contempt petition. My lord, accordingly, my lord, that the contempt petition, there are 7 numbers of contempt petitions she appeared, and 120, 140 has been, my lord, paid.
Then?
And earlier, my lord, there is she, my lord, given that, my lord, all the person, my lord, in the contempt, lordship.
So these are the 7, page
These are the
12.
same. And 30,000, the professional, it is also.
Page 13.
13. 13 is what?
13 is the page.
This was sanctioned.
Amount was sanctioned.
FOC?
Sanction order is a
Directly to convey the sanction of the
Lordship,
governor to an expenditure not exceeding so and so by appearing in the court cases in the social during the financial year as per the case file back in. Where is the annexure?
this was not provided to us. This is the bill that was enclosed along with it. This is the documented page number 13, Your Lordship.
Where is this annexure, Mr. Hendrik?
Lordship.
Annexure A to the document? Because that will make everything clear. Here also annexure A. Where is annexure A? Okay, Mr. J. Hendrik, the learned counsel appearing on behalf of the respondents shall produce the annexure A to the document enclosed as annexure D to the affidavit in opposition filed by the respondent number 2 in the instant writ petition. List the matter again on 28/8/2024. That's the answer. What is this, Mr. Sharma?
Regarding non-payment of contractors bill, my lord,
Contractual bill is not before bench 4. It's a bench 5.
what to have been reported.
Bench 4 matter, na? How did this matter arrive in this area? Has been included in pending liabilities area, which is pending for concurrence from the area. He prays for further 4. Yes,
Malad, this
4
matter,
weeks have gone.
that this matter may be disposed of with a direction. Malad, what had happened is that the DC had issued a tender seeking supply of food items during the 2018 Panchayat elections. He won the bid. Out of the total amount of 1,03,18,241, he has been paid around 25 lakhs. So the remaining pending amount, Malad, for that it may
82 lakhs 72,000. How much?
the amount is 78
8
lakhs.
crores.
No, 78 lakhs.
78 lakhs is pending, man.
Pending
1
liability
crore
of
is
some
what the
other
bill-
order is passed.
Bill amount.
Huh?
1 crore was the bill amount, 1 crore 3 lakhs 18,241 was the
Then?
bill amount. And out of that, my lord, only 25 lakhs paid. So 78 lakhs 18,241 not paid.
For food
Where is
items.
the admission?
For
78
said
lakhs.
election in 2018.
So this is Gwalpara?
No, no,
Petana.
Borpeta.
See, Borpeta, where? Total expense of fund against release so and so. Where is it mentioned about your 78 lakhs?
No, we have filed the bill, my lord. We have submitted the bill amount. my lord.
Then
And then bill was submitted. my lord.
why you are not filing affidavit?
Lordship may kindly see that page 16, my lord.
Now, how can this score
My
this
lord,
one?
Actually, the onus lies on the DC to authenticate, verify the bills which have been forwarded to
That
him
is-
by the petitioner. After the DC authenticates the bills, he forwards it to the State Election Commission. The State Election Commission forwards it to the PNRD department seeking release of funds. The PNRD department forwards those bills to the finance department seeking funds. So unless and until, my lord, the bills are duly authenticated by the DC's office and thereafter forwarded to the PNRD department, who will then forward the authenticated bills to the finance department, funds cannot be sanctioned by the finance department for payment of the pending liabilities. So directions may be
Place the order upon him for
DC.
approval, please.
DC, my lord. The tender award is at page 14, my lord.
Please.
14. The DC writes to the State Election Commission seeking funds. So
Now,
it's
this
like
is it. Now, the DC,
the DC then writes to the State Election Commission.
now, the DC just says that, okay, he let him supply whatever maybe.
Bids were invited. So his bid was,
What was his bid?
that he had. It's just that the award is next in this writ petition, but at page 14.
In this case, my lord, on 24/3/2023.
No, Mr. Sharma, I think you need to be more clear to get a better order. This type of things, you say that this is the amount, because otherwise what is happening, we have a council like Mr. P. Bodler and others said, this is not, you would never get in your lifetime. You may get it next. Your sons or daughters or granddaughters may get it. May not get it. So only way to get it is this. Come up with a more clearer picture by filing additional affidavit that this is the contract which happened. And this contract has happened. This was the contract value on which I was given. And this is why, and I supplied, these were the bills which were not given. Now, then what happens? I can hold the DC. I'm not bothered with what the State Election Commission, how they do. We're not bothered to that. Their DC has given you an order, they have to do it. And if they don't do it, we'll take it up. Or something. This type of petition.
File an additional affidavit.
Because it is not clear. It seems as if it is, the DC has given you a work order, there is no mention also. How much, what amount?
Definitely, my lord.
Let him withdraw it and file a fresh.
No.
Yeah.
Why should he withdraw at this hour? Again, file?
My lord.
And my lord,
Okay.
in this
What
case,
is
my
it?
lord. on
And
24/3
after 4 years, if he withdraws and files again, then his client will ask him, what is wrong with you? The earlier judge never said why this judge has done. Mr. J. Sharma, the learned counsel appearing on behalf of affidavit bringing more further, furnishing further details. In the meantime, the respondents are directed to file, respondent with DC, directed to file the affidavit as regards the entitlement of the petition.
May I pray for
Is
date?
the matter again on 18th of September.
Right.
Is which, DC is which respondent?
Question number 5.
Right, huh?
Right.
Yes, what is this?
I will kindly peruse the order dated 25th of. Big order was there.
What happened with you? What is your case, Mr. Nath?
Matter is that a portion of the building has been acquired by the NHIDCL. And in that portion, one joint portion was there. The portion has been acquired, belong to my cousin. And that adjacent portion belong to this petitioner. So when that portion is demolished, my portion is also hampered. But my portion was not never, my lord, surveyed or anything else was done. Although I filed application, Deputy Commissioner forwarded to the circle officer for joint verification. Thereafter, deputy, circle officer forwarded to the PWD for joint verification. Nothing was done. Therefore, I have filed this petition where one direction was there to the PWD to join verify. Thereafter, that as per my instruction, that was already submitted before the deputy commissioner. And I have submitted that also. I have obtained it. So
And-
that was to be verified by the deputy commissioner,
Then,
but nothing is yet been given, my lord.
nothing is there.
That final report I have submitted, that is to be.
Conduct a joint survey to ascertain the sustainability of the utility habituality and standing
My lord,
and pay adequate compensation under the National Highways Act.
that is not done.
What happened, Kala?
Lordship, this is the, your lordship right order dated so lordship there, which were directed to is the present status report, lordship.
WD has already verified. Payment is not yet given.
Right, right. And thereafter, if your lordships go by the affidavit filed, not, sorry. My own. What have
Yes, requiring body. Your instruction.
Lordship, I have a file affidavit, my lord.
What do you
Page
say?
45, my lord.
Prior to
The
this.
structure of the building is not included in the proposed right of way, lordship. It is approximate, lordship, 4 feet distance, lordship, from the right of way, lordship.
So you mean to say that if you have demolished, if NHAI or state have demolished any part of the building of the petitioner, would not come within the ambit of the National Highways Act. Did you understand that? Then we give him the permission to file a suit without being here against you and him, and claiming here and the bar contained in the National Highways Act, you have waived it. As regards the damage caused to him, you say that it is outside, meaning thereby he is entitled, if any building has been damaged out there, without there being on a right to way, obviously he is entitled to some compensation. You pay. We'll take it as your submission that it is outside the ambit of the National Highways Act. Okay? Let's dispose it of.
7C specifically states. Section 3G, 7C.
No, there therefore stand is very clear that this is house is outside. So I think the best option is that you cannot file. If it is not brought within the ambit of a notification under section 3A, C or D, you cannot file there. So what are you going to do? You file a suit and the bar which is contained in the National Highways Act here. So independently you have to pay whatever damage. Yes, so we'll prove it.
Hello. What? Trying to say that it is not on the right of way, but right of way in all those buildings where right of way goes within the building, the remaining portion up to one limit is given. So my building is a joint building.
Now, have you brought in that circular whereby it says that if it's to a particular pillar, the next pillar, till the next pillar it is given?
Kindly come to page number.
Have you brought that circular? if the right of way falls in the last of the pillar or touches a part of one pillar, till the next pillar they have to give you the compensation?
It is already given because suppose this is the right of way, they have given to the next pillar. And I am not claiming the whole pillar. I am claiming only 2 rooms that was initially considered. Kindly come to page number, their own document. Well, kindly come to page number 23, Annexure 7. This is the drawing
20?
23, Annexure 7 of the writ petition.
Hmm.
So this drawing, left part is my building, right part is the
Left
portion,
part is where?
the middle line, ROW,
Where is the ROW?
right side below of the drawing.
Huh? Your page annexure 7. Yes, where is ROW?
There is a word ROW at the bottom
Ah.
of the drawing. This is the ROW.
Ah,
right of way.
ROW.
So, in fact, affected building of my cousin is this part. The
Which
2
one?
rooms, the 2 rooms.
Affected building RCC second story.
That is my cousin's.
Okay, where is yours?
Exactly with the right.
RCC ground floor, room 2.
Yes, left side, this line, cross line is there. That is my portion. I am claiming only this part. And it is exactly on that next beam.
Therefore, I am asking you,
Adding a
what
common building
happens in view of that circular? If your right of way falls, does this person is getting the compensation
Yes, that other person already paid.
and they are not including this. The right of way goes how?
This cross line, corner line.
It is outside.
Exactly cannot be said.
The
outside.
last of the right of way is this.
This line, my lord.
Then it is outside your room.
But the payment is given to the next bill. The payment is given to the next bill.
That is what I said. Where is that circular?
It was a
behalf of the said respondents submits that the said companies have duly decided to pay the petitioner the due compensation. However, the same would require some time to be finalized. Accordingly, list this matter on 4th of November 2020. The learned counsels appearing on behalf of the parties shall update shall shall give an update as regards the status of the negotiation. The court expects that the said negotiations and the settlement be completed on or before the next date.
District administration is also being involved because that is the deputy commissioner.
I've given the attendance who have that appeared in the.
Sometimes you don't need to pass judgments. Isn't it, Mr. Patel? You don't need to pass judgments. Yes, what is this?
My lord, that arbitration matter, my lord.
Which one?
That whether the general manager can appoint the arbitrator or not, my lord.
Oh, yes.
My lord, I am placing two judgments of this no court, my lord.
Uh-huh.
First case, my lord, that is Varpeta Agro Infra, where my learned friend appears for the respondent. My lord, there are 12 owners, my lord, I said.
I told you last time. Here it says by the constitution bench. It is not open unless specifically directed by this court to await an outcome of the reference or a review petition,
That's correct.
as the case may be. It is also not open to the High Court to refuse to follow a judgment by stating that it has been doubted by a later coordinate bench. In any case, when faced with the conflicting judgments by the benches of equal strength of this court, it is the earlier which is to be followed by the High Courts as held by the 5 judges bench in so and so.
And
The High Court, of course, will do so with careful regard to the facts and
Perhaps that was under 11.6 or 12.5 petitions, and this is writ jurisdiction.
Huh?
This has been in, here in writ jurisdiction has been invoked. And that was lordship perhaps 11.6 or 12.5 petition.
11.6. But here, he judges tribunal was formed, that was that side.
that is not only this, and that too, this judgment is not binding. This judgment which is being passed in these cases, in arbitration petitions, are not binding.
But no, what is here, but I am submitting.
Are they binding? No, it can't be binding on us.
My lord, your office will see paragraph 23, my lord.
No, that is one, but
My lord.
that
Because
day I was coming across one judgment which says that when there are conflicting of left for the court to decide. say that the earlier is to be followed.
My lord, that Supreme Court judgment has been said, my lord. My learned friend has referred to Union Territory of Ladakh, my lord, that has judgment been followed by it. And
No, let us see the Constitution bench judgment, where does it say? I don't think the Constitution bench says in that manner. The earlier has to be followed.
because here the judgment has said, my lord, that the main type was another point.
The problem arises with when you take note of judgment. There's another judgment. What do you do? University says this.
Yeah.
Here to that, there is another judgment of A. Hasira, that is a 5 judges bench, which says otherwise. Then what to do? Tell me.
National Insurance Company. That was one. National Insurance Company.
That is 5 judges.
Yes.
You have another 5 judges, headed by Justice Bharucha, which categorically says that when there is a conflict among coordinate bench, it is left to the courts to decide.
But which is to be followed, that is to be.
Then how do you take care of that? If you follow this very judgment, then the earlier constitution bench is to be followed. I think what was meant by the Supreme Court in this manner.
Fact, my lord, Supreme Court is also not following central organization case. Another case, my lord, Justice Jasper Singh, while he was here, he also, my lord, kept the matter pending. The party went to the Supreme Court says that we are not following the central order, they have appointed independent arbiter. I have got the copy of that.
Say what the Supreme Court says in that constitution. The problem, no, just time from here, there.
So mainly aspect is this, my lord, he had 12.
He
facts
says,
in Congress.
yeah, state of Riyadh, but it never said like that. Court has accepted the said principle on the basis of so and so. It may be said that the constitution bench clearly stated that the prior constitution bench is binding precedent. Be it clarified that the issue that were put to test in the earlier constitution were treated as precedent by the later constitution bench. Regard so and so, we may draw the passage from another judgment. This is another. The aforesaid were articulated in the context, yet has been following. Judges bench. This is it is only when the 2 judges bench cannot be reconciled with later 2 judges bench cannot be reconciled with the earlier two judges bench, then only it can be held to be earlier judgment will be. Not because it is earlier.
My lord, there is a judgment of Calcutta High Court also, and moreover, my lord, here the another factor is this, my lord, this honorable court considered that there is a no waiver of 12.5.
Huh?
12.5 has not been waived. In our case also, we have not waived the 12.5. We have still said that we have not waived 12.5. Section 12.5, my lord, we have to waive. Otherwise, it cannot be done, my lord. At para 22, my lord. Arbiter.
But how are you challenging the tribunal's decision? The constitution of the tribunal under Article 227.
My lord, that is what we are saying that we don't do it.
How are you challenging that?
In exceptional case, it can be done, my lord.
Oh.
My lord, yes, government has to. My lord, our prayer is only, my lord, that when Supreme Court, that the matter is pending, the matter may be kept in appeal.
No, that cannot be.
My lord.
Because of the clear dictum of that judgment in Union Territory of Ladakh's case. Categorically says that it is not open unless specifically directed by this court to await an income of a reference or outcome of a reference to petition as the case. So the law is very clear. That you can't wait for that.
But here, my lord, this has also been held, my lord, that the earlier judgment is to follow. Here, as per that,
We
my
may
lord,
follow that, but
that here,
then- okay, let us assume that let us follow the earlier judgment.
yes,
We will follow that. But the question is, the question of keeping it in abeyance does not arise. Has to be a finality of the. Will have far-reaching consequences because you are otherwise enjoying a stay.
so in that case, my lord,
In fact, the stay should have been made only subject to the constitution of the year. The
No,
moment they are entering into
no, in that
reference, the
case, my
matter
lord,
would have been ended.
we will be allowed to file a petition under section 11(6).
Huh?
11(6) also, we can be allowed to file a petition under 11(6). Because in this case, my lord, the earlier constitution of the tribunal has been set aside. By the Honorable Court. In this case, Borpeta Road. Borpeta.
What?
Borpeta Road, my lord, case.
Pedro, where is the
Borpeta,
book?
sorry, Borpeta Agro,
What happened?
my lord, paragraph 25.
This is obviously done under the arbitration petition.
Yes, let's go to 11(6), my lord, in that case.
Who they?
Hello.
Who they? You can approach them, then they can appoint an arbitrator also. Kumar Bhattacharjee, retired district judge. So the third arbitrator will be appointed.
Hello.
Third arbitrator will be appointed by them. One you have already selected. The second is to be by them. The third is by,
The third is to be appointed by the two arbitrators.
they have not appointed, somebody else have appointed.
Yes, that is
So
the, my lord.
that is the issue. But can this court under 226 adjudicate that issue? As it is in within the realm of the Arbitration Act?
My lord, when we have not waived 12(5), my lord.
Very well.
Yes.
But are any of these cases wherever Perkins or this central have given a rise from 226?
My lord, 227 also, my lord, it can be.
227 is different. I'm not on 227. Don't come to
Well,
227.
I'm 1 minute.
No, 227. All these matters, these are all 11.6.
Well, I'm,
This TRF is 11.6. Then you see, look, what is this? Conciliation. This is also an 11.6. 11.6 for appointment of an arbitrator. Then you can come and challenging the authority, but the problem arises, you cannot. This is also an 11. It can be done in this manner. Central organization is also 11.6. Fields have been prepared under arbitration. This is 11-6. Perkins is also 11-6. Why should this court entertain under 226?
Moreover, the arbitrator was appointed on the basis of the admission made in the lordship page
No, we
68.
have- Prior to that, my
Page
lord, we have
68
filed a
also.
petition. I can place, my lord, that we have not waived to 12-5 and this is the Court judgment. Before giving me the copy of that. my lord.
No, whatever may be, but these, why will this court entertain 226?
My lord, your lordship just messy, but. That is at page 70.
Of?
Page 70 of my report. This is prior to giving me the four names. And at page 71, my lord.
No, I'm not on those. Let us not, let us,
we have said,
but what can
uh,
this court do? No, I have seen your thing, that you categorically said, kindly see page 71, the last portion, you categorically say, I remember that. Don't worry. But the only question is, why this court should exercise 226? Because this will be opening all floodgates every time.
my lord, in one case, Supreme Court has said, my lord, in Deep Industries Limited versus ONGC. 2020-15 SCC 706. I'm not having that, my lord. 2020-15 SCC 706.
What does it say?
But it says, here the High Court would extend circumstance in interpreting the same, but taking into account the central policy example by us in above, so that interference is restricted to the orders that passed, which are patently lacking in inherent jurisdiction under 226.
What orders? Here there is an arbitration tribunal.
Correct, my lord, that is inherent, there is no jurisdiction.
No. 226, nothing big. Can't pick up one word from here to there, this will come. 26, no. 11-6, 12-5, whatever may be. That person is not there. There is a jurisdictional issue. Cannot be decided.
My lord, in such case, my lord, where this honorable court also held that PRF is the binding, my lord,
Understood, TRP is binding, but can I invoke TRP here? Into
and will they be allowed to, my lord, file a petition?
let's take up this matter on Tuesday. Next Tuesday. We give a thought if it can be done. Because what is happening, Mr. Chaiwala, only worry what I am saying is, if I exercise, I may pass an order in your favor, but if I exercise 226, would it have an impact? Bigger impact. Because every time, whenever the challenge of jurisdiction will come, they will come to under 226. This is a very serious thing. Because otherwise the Arbitration Act mandates do what is to be done. Why should this go?
My lord, another judgment of our Supreme Court, my lord, that is 24 SCC 341, my lord.
What does it say?
My lord, that is also, Chief Justice was a party in this matter, my lord.
Chief Justice is he's also a Supreme Court judge.
This is three judges bench, my lord.
It make a difference.
85 to 92 paragraph.
This is an application under section 11(6).
Well,
Did it? That is why I'm saying. See, the worry of this court is not that. The worry of this court is, if I do it, it will open floodgates. I don't want to do all these things. Bringing in, allowing arbitration proceedings, jurisdictional arbitration proceedings being challenged here.
well, can it be fixed on 20th, my lord, March Junior?
Same also his designation. 20?
20 August.
Is this matter again on 28 and 24? Matter having been substantiated again on 28. On which date an attempt shall be made to dispose. Only problem is this. You sought for time now in the morning. Wait. Then your matter is gone for a 6. Nothing is happening. They will not gonna stay also. December? November? November. This is the matter. The council appearing on behalf of the petitioner seeks an accommodation. This is the matter on 11th of November 2024. Yes. Vacated? Vacated?
A part vacated. Okay.
You are in possession of how much land?
3 kathas.
49 bighas or something.
Around.
Now you are in, here it says has ever the petitioner's family is in occupation of,
Also 49 bigger.
now you have been vacated.
No, not yet. A part of my house is demolished.
Then where is the notice? What instruction?
That's not received the instruction, let's say easier land.
Vizier?
Yes.
Where file your affidavit? Or do you have any document?
So he has stated here in the synopsis.
Stated?
Notified
Vizier
building
land.
reserve.
But government already reserved a portion already.
No. Has the government de-reserved it?
Not yet. A part of the land, there are 100 families. I am one of them only. Only I am single out. I don't know why. And out of that, 49 bighas, a portion already reserved. And
De-reserved?
Yes. Yes.
Where?
I mention it in page number 7, point 10. There is an application also.
No, you just find out as to whether the petitioner who is in occupation is in Vizier land. Mr. Ivachaji, the Learned Council appearing on behalf of the Revenue Department shall apprise this court on the next returnable date, on the next date, as to whether the petitioners who is in possession of the land is in is is a VGR land. So it is also, this court further directs the state respondent authority to also apprise this court as to whether there has been any proposal for de-reservation of the land of the petitioner, where the petitioner is in occupation. This is the matter again on 28/8/2024. In follow.
Lordship, on this matter, we would like to file affidavit. Our affidavit is ready. We will be filing on Monday, Your Lordship.
Huh?
We will be filing our affidavit on Monday. Our affidavit is we received
Monday?
Monday.
Mr. R.R. Gogoi, appearing on behalf of the Forest Department, submits that the affidavit on behalf of the said department would be filed
Monday, Your Lordship.
without fail by Monday. It is seen that on various occasions, time have been taken by the Forest Department in that regard. This court grants a final opportunity to file the affidavit by the Forest Department on or before 19th of August 2024. Full stop. The petitioner, if so advised, would be at liberty to file their reply by 28th of August 2024. List the matter on 30/8/2024.
Pursuant to your lordship's order dated 3/8, my lord, have received the instruction.
Yes, report.
Regarding position of the. Petitioner position.
So if petitioner is in possession of the schedule B, C, D land.
Yes. These are all go down. All go down, constructed over the land.
Now, you have filed a suit, Mr. Roy? It's pending?
Pending,
You got an injunction?
injunction, dated 27/2/20.
Okay. Then why did this person is not a party? That person who is doing the mischief
He's a party.
in that suit?
Yes, in the suit, he is defendant number 28. And here he is the respondent number 8.
Is a party.
Party.
So it is he who is doing it.
Okay.
As per you, he is doing it.
Yes, Lord. We are having my lord, the video recording of entire demolition and
Okay.
presence of the respondent number 8, lordship. And the petitioner is now not in a position of any part of the land and building.
You are in possession.
No,
They say they are in possession.
no, lordship, please, I have annexed the plate. I have annexed the plate
This is the
also.
office.
Taking a prayer for recovery of position. Based on the Mondal. Absolutely managed report, lordship.
Huh? You are not in possession of BCD land.
Dictated lordship with 250 numbers of litigants had come along with the JCP dumper with the circle officer, hired police officers, lordship.
in the name of demarcation of the plot of landlordship, and thereafter they had evicted 25 numbers of tenants. The tenants are having the commercial rooms. They have also filed a writ petition, which is also pending before this honorable court. And after eviction of the petitioner and their tenant lordship, each of the tenant, 25 numbers have filed separate suits under section 6 of the Specific Relief Act for recovery of possession.
Who the tenants
Yes,
against you?
I am a performer defendant, but against mainly private respondent number 8, so Mr. Tumu.
So they have filed suits.
Yes, tenant. Lordship, I am having the entire video recording.
Then what to do?
Pen drive, Lordship, I am having. We will show the entire demolition operation with JCB and Portland and about 250 associate Lordship. I am having the pen drive, Lordship. Because here, Lordship, in the suit, Lordship, all the police officers, including DGP, police commissioner, OC, all they are part. That's why this is a managed affair, Lordship. I am having the pen drive, Lordship, and this was shooting was done through drone also, Lordship, Bhuvan app also, and ISRO satellite also. So let it be heard in some other day, Lordship. Such a injustice has been done in a democratic country.
We'll have it on 22nd of August. Because there's something to be done. Let them put this thing on affidavit.
Because Lordship, the powerful minister, he wants to purchase this land, BCD.
Who is that minister? You have named him.
Lordship, that is the difficulty. Will
They have not. Then why are you making the statement?
we have made a statement indirectly, not directly.
Indirectly is not
Lordship knows why.
Not there. Anyways, so pursuant to the order passed on 2/8/2024,
Lordship, that may be
The-
23rd.
no, 22nd. 23rd is a Friday.
I have about 7-8 cases.
If you have no
21st,
urgency,
21st.
if you no urgency, we'll have it on 10th of September. Pursuant to the report so far on 2/8/2000, by an order dated 2/8/2024, Mr. BJ Talukdar, appearing on behalf of the state respondents, have submitted a report saying that the petitioner is in possession of Schedule B, C, and D lands. Taking into account the said report, this court to direct the circle officer, Guwahati Revenue Circle, Guwahati Revenue, Dispur Revenue Circle, to file an affidavit bringing on record the state report. This court further fixes this matter again on 17th of September 2024. Interim order passed early, it shall continue.
Interim order.
Till then, I'm handing over back to the.
A copy of the report will be given.
Well, let him bring it by way of an affidavit.
Public. I am having other matters. I don't. 41. This will be taken some other day. Contempt matter.
$39?
41. 41.
By orders? Who is respondent number 7?
This is the person money who took my property.
Huh?
I purchased the land. of, The respondent numbers further respondent numbers. But when the compensation was granted, it was granted to one of not my lord.
Taking into account the this note, the service is deemed to be complete. It's the matter for admission in the in the second week of September 2024. Yes, what is this affidavit why you have not filed?
Matter, my lord. Order against which this evidence has been alleged, my lord.
Why you have not filed the affidavit?
Lordship, I have recently received an instruction, Lordship.
Recently, you have appeared on many occasions earlier.
But
Here
this
is
is
the
a,
flag
this,
B, 1 minute.
No, I
No,
think
this
this person needs to be appear in person.
Lordship, this is the compliance report.
There is a
We
flag
should
B, my
stop
lord.
this giving all these things. Who are these? You have
Lordship.
complied?
No, no, compliant, Lordship. This is the communication I have.
My lord, if your lordship peruses the flag B, my lord, in the lordship's file, my lord. The contempt
What is the order?
My lord,
Contempt.
order lordship will find page 38, my lord. Page 38, paragraph 9, my lord. Very serious matter, my lord. But there's a simple direction.
Decision has been taken by the complainant, namely Vishwanath Rengana, on the complaint lodged by the private.
Personal hearing has to be given, my lord, specific.
Who is to pass the order?
My lord, the chairman, my lord. The contender. Now what has happened?
You are saying about the 2/11/2022. So they have passed.
No, my lord. If your lordship peruses the flag B, there is a flag B, my lord. They have written to the registry of the court that where my stand is vindicated, my lord. That the particular written statement which I have submitted, let alone a personal hearing, my lord. My written statement was not considered, my lord. That is what is reflected in the flag B, lordship. In your lordship's record, my lord. I could not take a certified copy of that particular letter, my lord. There is a flag B there, which is a letter directly written to the so-called notice. Copy is marked to the register of our court, my lord.
Flag B.
B, my lord.
B. Who is Pavitra Burwa?
My lord, I do, there's some employee of theirs head assistant. My lord, now that head assistant has been so close because my written statement was not placed before the authorities, my lord.
But in terms of this order,
My lord, now that there is a conflict, my lord. If they have given it, because my instruction is from my client is they have neither given a hearing nor given or passed a reasonable order, my lord.
Whether it is reasonable or hearing, that is the subject matter of another proceeding. Not to do with this.
But order has not been complied with, my lord.
It has been complied with. The order passed.
the order, Lordship. I have received the communication.
Keep it on record, give him a copy of it.
Can it come through an affidavit that, my lord?
Why? It's you are at liberty to challenge it. Court heard Mr. G. Rahul, the learned counsel, appearing on behalf DJ Speedas appearing on behalf of the two respondents. The instant petition in contempt application has been filed challenging the alleging willful and deliberate violation to the order dated order dated
2/11/2022, Lordship.
2/11/2022 passed in WPC number 2354/2021. This court duly takes note of the said order wherein there was a direction passed to the Biswanath Shariali Municipal Board to pass an order strictly in accordance with law and by taking into consideration all relevant facts, including the trace map and the building drawings which were furnished at the time of grant of NOC. It was also directed that the said exercise be completed within 45 days from the date of receipt of the written statement from both the parties, which have been submitted within 3 weeks, were to be submitted within 3 weeks from the date of the said judgment. It is further stated, Mr. Didas, appearing on behalf of the respondent number 1 and 2, submits that in compliance to the order dated 2/11/2022, passed in WPC number 2021, the order have been duly passed by the Iswanath Sariali Municipal Board on 28/4/2023. Taking into account the said order having been passed, the said order is deemed to have the same order passed was taking into account that the order has been passed was the instant contempt proceedings stands closed. However, the contempt proceeding stands closed, and the initiation of the contempt against the respondent stands dropped. Be that as it may, the petitioner herein would be at liberty to challenge the said order dated 28/4/2023, if so aggrieved. The contempt order, the order instruction as well as the order dated the instruction dated 6/5/2023 as well as the order dated 28/4/2023 are collectively kept on record with the letter X.
And if you,
Can it be taken on some other day? Deputy in reply has been filed.
Reading is complete. Reading is complete.
What is this? Contempt?
Contempt.
What is this pleading business?
Reading is, reply, they have come out a reply, what are the counter?
Contempt for what?
Of the order,
Where is that order?
Page 54 here.
54. What is the direction? Having regard to the grievance raised in the rear, this court is inclined to provide that the pendency will not be a bar for the competent authorities to revisit the order dated. What? Is this against this? We are filing a contempt against what order?
It's an order dated 10/1/23 or
Then
10/1/23, which is at page 54.
10/1/2023. What is the provided that till disposal of the appeal filed by the petitioner on remand before the standing committee responding authorities shall not demolish the structure of the petitioner which is pursuant to the impugned order dated so and so, and the operation of the order is stayed. Then they demolished.
what happened?
Order and demolish.
Huh?
The order notice dated 21/10/22 and issued a fresh notice
Shall not demolish the structure of the petitioner which is pursuant to the impugned order dated so and so, and the operation of the order is stayed. So they recall this order of 1612 and then demolish by issuing a notice. Now, did you challenge that notice?
not at that given point of time.
Then?
It was when
Because the main challenge is that the particular notice was without jurisdiction by it.
So you recall that notice
The notice.
and
notice
issue the
was there.
fresh notice and they
After there is no challenge, nothing, my lord, after the demolition
Then
was done.
what remains?
can it be taken on some other?
Yes, why did your senior leave immediately? He was waiting out here. The other matter was bigger. It's more lucrative. Then these never matters has to finish. I'm not getting anything unless chalo. The counsel appearing on behalf of the petitioner seeks an accommodation. Is the matter again on We'll finish it off. 28th of August 2024 at 2 p.m. Finish it. That type of matters should not be made. Yes, Mr. B. Bolwa.
This
What are these? Complied,
last order direction or issued to them.
complied or not?
Our party is complied, Lordship,
Who has not complied?
state government, because we
Yeah,
have
the-
additional fund from the state.
Why state has not complied?
But this instruction is not within my knowledge, but that is instruction. My instruction in the month of March, I have received that 73 crore rupees given to the NC Hills. And one of it is the NC Hills authority, they have to disburse the amount. Yes,
We have disbursed that.
but in that case, Lord, I need some time, Lord, whether the petitioners, they have given the petitioners or to whom of that, and what additional fund is required, that I have to say.
Dina, the learned counsel appearing on behalf of the respondent number 5.
I am appealing for respondent number 2.
Huh?
For respondent number 2.
5?
Yes, madam. 5 is the implemented.
No, you are appearing for 5.
5 and 5 is the
Five.
engineer.
5.
Admits that he requires to obtain certain instructions in view of the statement made by Mr. R.M. Das, appearing on behalf of the respondent number 1, that from the side of the client of the respondent number, client of Mr. R.M. Das, that from the side of the respondent number 1, the order have been duly complied with. List the matter again on 11th of September.
Both same, madam. 42 and
42, 48 is here.
42 and 44.
Get out. Yes, what is this?
Lordship, filed improvement petition that has been filed on 19/6, but due to some typographical error, the IA could not be numbered, Lordship. So may I pray that IA
What order is this?
regarding
In
Lordship?
view of the broad consensus arrived at so and so, instead of keeping the original area disposed of, Vishnu shall submit a representation with regard to his request for addition of beneficiaries to his bench so and so, 2 weeks from so and so and so. Nobody is appearing. Ms. So and so submits that the implement application has been filed. However, the same is not come on record.
13th Lordship.
Huh?
On 13th Lordship.
You have filed it. Ah.
35th Lordship.
So the registry shall list the instant application, proceeding along with the said application after 2 weeks.
Lordship, a long time. Can it be on 13, 14 or in earlier Lordship?
Okay,
13th Lordship.
on 21st of August. Oh, this one. What happened?
We have filed a review petition, Lordship has issued a notice in the matter, my lord. Otherwise, my lord, for the respondents, we have.
Review petition doesn't mean sustain. Today I was reading a judgment.
My lord, kindly, I would pray to take up this matter along with the review petition, my lord. There,
Who has passed that order?
Lordship,
Huh?
Lordship,
My judgment.
Lordship.
What happened?
My lord, the direction is to release the amount of rupees 11 lakhs.
Huh.
However, the NHIDCL, they are to deposit the amount. They are not depositing.
There was a direction, something.
Lord, kindly come to page 15. my lord.
Another matter I directed, the similar order was passed.
My lord, we moved the review petition before your Lordship.
Where I have directed the
Notice
for
is
the review petition to be listed along
along
with
the
it.
content. This is the
We have
content.
filed a review.
Yes, my lord. In the affidavit, we have stated, my lord,
Learned counsel appearing on behalf of Mr. Deep, appearing on behalf of the respondent submits that a review petition has been filed against the order dated 11/9/2023 in WPC number 9534/2000, seeking review of the order dated 11/9/2023 passed in WPC number 9534/2019. And
Plus
say the review petition has been registered and numbered as,
120 of 2024.
to list the instant contempt application along with the review petition after
Firstly,
2
we need
weeks.
3 weeks time to file the reply to this affidavit, my lord.
Huh?
It 3 weeks time to file the.
Where?
reply.
In
Their
this?
affidavit, my lord, in the contempt, my lord.
Feel it. And you file, if you want to file, you file, that is your lookout. On list the matter on 6th of September.
My lord, my senior, Mr. D. Borua's name is not reflected, my lord. The case is conducted by him, I am his associate.
If he was present, I would have not looked up. Yes, Mr. P. Das. Got the instructions? Now, in view of section 8, the adjudication having been done, the PMLA or the enforcement directorate will have a better claim than the respond number 4. So direct them to hand over the amount to them. Pass the order. I'll pass the order, get it better.
Relieving the bank from any other liability.
No, I'll say that if he duly complies with it, yeah. Or we do one thing. We take it up on Monday at the top of the list at 10:30. Huh? Mr. R.K. Dev Chaudhary, the Learned Council, DYSCGI, have submitted the instruction as sought for. With the possibility of time as the order cannot be passed in their bed. It's the matter on 12/8/2000, 12/8/2024. At the top of the list. Probably so at 2 o'clock. Convenience is you. You are the most busiest person. At the top of the list. The interim order passed earlier shall continue till the next. Obliged. This instruction you want to give?
Oh, no, sure, I have got a copy.
The copy of the said instruction is kept on record and we'll pass that on, but I want to pass it. I don't bring any file back home.
Gosh.